Hello, everybody who's coming in. We are starting back on our landmark cases to care about. And this time, we did all our firearms cases. Now we're doing cases involving women's rights. One of the very first cases, it's not the only case, but one of the very first big cases that came up for this is Griswold v. Connecticut. So Griswold v. Connecticut examined birth control and the right for married couples to make that decision. So, without further ado, we are going to listen to oral arguments. Now, this is a more unusual one because a lot of people aren't going to be used to. I'm sorry, I'm trying to dock this chat and I do not know how to do it. But they changed TikTok Studio on me. So we are going to be going over Griswold v. Connecticut today. We're starting back in landmark cases to care about. Griswold v. Connecticut was a key decision involving birth control and the right to privacy for married couples to make medical decisions. And law, as always, you are very welcome to come up whenever you would like. If I can figure out how to bring you up. This is, I'm new to, they reset my setting here. So I honestly don't even know if I will see you request. Can I make somebody a mod to bring him up? Because I really don't know how to use this. They just updated it like today. Okay, well, maybe I'll figure it out by then. Hold on one sec. Oh, there it goes. Okay. I'll accept you, but you can chill if you need to. Sorry about that.
No worries. I'm going to finish getting these coops ready for the storm that's coming, but I'll be listening.
No worries. All right. So without further ado, guys, we're going to be starting Griswold v. Connecticut tonight and get ready to go. Oh, what I was mentioning before, I'm so sorry. So back in the day, oral arguments, there would sometimes be multiple days of oral arguments. This is a case of that. It was argued on March 29th, 1965 and March 30th, 1965. This will take about 2.5 hours to get through. So settle in and buckle up, everybody.
Number 496, Estelle T. Griswold et al., appellants versus Connecticut.
Absolutely.
Mr. Emerson.
Mr. Chief Justice, may it please the court. This case involves the validity of the Connecticut anti-contraceptive statutes. There are two statutes involved, which are printed on page 3 of our brief. The first one, which I will refer to as the use statute, provides that any person who uses any drug, medicinal article, or instrument for the purpose of preventing conception is guilty of a crime. And the second statute, the accessory statute, provides that anyone who assists, abets, counsels, so on, another to commit any offense may be punished as if he were the principal offender. There is no dispute concerning the facts of the case, at least so far as I know. Following the decision of this court in Poe against Ullman in 1961, there was opened in New Haven the Planned Parenthood Center. This was in November of 1961. The purpose of the center was to provide information, instruction, and medical advice to married persons as to the means of preventing conception and to educate married persons generally as to such means and methods. That was the finding of the court in this case. Dr. Buxton, one of the appellants here, was medical director of the center. Dr. Buxton is chief of the Department of Obstetrics and Gynecology at Yale Medical School and one of the leading authorities in his field. Mrs. Griswold, the other appellant here, was acting director of the center. She is executive director of the Planned Parenthood League of Connecticut, and she was in charge of the administration of the center and its educational program. The center functioned in a suite of 8 rooms in a building in New Haven. It had a staff of doctors and nurses as well as Mrs. Griswold. The procedure was that when a married woman came to the center, she was interviewed, her case history was taken, and the various forms of contraception were explained to her.
Professor Emerson, how was the determination made that she was a married woman?
I do not know, Your Honor, except that in asking questions and taking the case history, I assume that it was accepted if she said she was married. But I'm not sure what the arrangements for that was. There's no question in the case but that the center functioned only for the purpose of helping married women. Yes, there's no question about that. If an unmarried woman got services, it would be through misrepresentation and mistake.
I want y'all to listen to what he just said. If a married woman got services, it would be through a misrepresentation and mistake. Like, I just want you to imagine being a woman before this decision, 1965. This isn't even 100 years ago. And they were deciding whether a married woman, not even just like a single woman, which is going to be our next case, which is Eisenstadt v. Baird. Sorry, I was about to say Blart for some reason. Eisenstadt v. Blart, which is what we go in with single women. But imagine being a woman less than 100 years ago, and men are sitting here at court trying to tell a married woman whether she can prevent pregnancy in her own marriage. I just want you to conceptualize how insane this is. I digress.
That's right, Your Honor. That's right. That's right. Yes. Yeah.
Does the law allow that distinction? Discrimination?
The law makes
Exactly,
no distinction
Priscilla.
between married and unmarried women, but our objection to it essentially goes only to its application to married women.
Well, why wouldn't it be a denial of equal protection of the law to draw such a distinction? Women need that.
Well, it might be, and I will argue that it does operate discriminatorily, Your Honor. The equal protection question as such was not raised in this case. And there might be differences between married and unmarried women for purposes of legislation in this area, so that the mere fact of distinction would not necessarily be denial of equal protection.
Professor Emerson said you're not making an equal protection argument. That reminds me, is or is not the sale of contraceptives a crime?
Yes, it is, Your Honor, by virtue of the accessory statute.
That is, would it be, for example, also the crime of aiding and abetting a violation of the use statute to sell contraceptives?
Yes, it would be, Your Honor.
Have
Yes.
there been any prosecutions for that?
There have been no prosecutions for sale, Your Honor. The only prosecutions actually have been in the case of clinics, where the prosecutions have been brought against doctors, nurses, and assistants.
Yeah.
Listen to that so carefully and think about how states, and listen, I get it. It's not the same comparison. I get this shit. But think about how states are implementing overwhelmingly sort of the Dobbs decision. They're not going after the patient. Oh no, they're going after the provider. Just saying.
what you said would be correct if contraceptives were sold as contraceptives, but I suppose if they were sold as something else, as preventative of disease, that would not violate the abetting protection. Is that right?
That's right, Your Honor. In just 1 minute, I'll get to the interpretation, the Connecticut state interpretation of the statute.
Just one other question on that subject, if I might, Professor. There's no authorization for the prescription of contraceptives to prevent disease or that sort of thing?
No. Well.
Hey, I'm so sorry. If you're down in the chat, I promise to get right back into this. If you can just tap the screen and send the heart, like that little 1 penny heart me thing, it helps my life so much. Otherwise, I don't ask for anything from my viewers. Y'all sitting here with me is a gift enough, but it just helps the live grow. So I would appreciate it if you can. If not, if you can just tap, I would be so appreciative. Thank you so much.
The statute applies without exception to prevent the use of contraceptives for purposes of preventing conception. The statute does not apply to the use or sale of contraceptives for purposes of preventing disease.
Well, is that the way that contraceptives are freely sold then?
That's correct, Your Honor. They are sold in Connecticut for purposes of preventing disease.
And yet you're making no equal protection argument at all.
We are not.
Did he just say contraceptives were preventing disease? Is that what I just heard come out of this gentleman's mouth? Because look, there's a lot of things birth control can do. It's not going to prevent STDs. Thank you so much.
I'm not arguing equal protection clause of the 14th Amendment as such in this case. No, it was not raised in that way. We do say that the statute does operate discriminatorily and as part of our due process argument.
For the purpose of preventing disease, no distinction is drawn between married and unmarried.
No.
Correct?
Well, there's no statute which says.
Oh, I got you, Law. Okay, so that was the workaround. Gotcha. Thank you.
It's simply that the statute doesn't cover the use or sale of contraceptives for preventing disease. That applies to anybody, yes.
I take it that applies across the board.
That's right. The center functioned for 10 days, and then at that time, Dr. Buxton and Mrs. Griswold were arrested, and the center closed down. Informations were filed against two appellants here, and demurs were filed to those informations, challenging the statute on due process grounds under the 14th Amendment and First Amendment freedom of speech grounds under the First and 14th Amendment. The demurs were overruled. There was a trial before the court without a jury, and findings of fact were subsequently made, which state the basis of the court's position. The evidence showed that Dr. Buxton had not only been medical director of the center and had made the medical.
When Law gets back, we'll get him to get into demurs. I feel like I could explain it. I've just never done enough civil work to fully understand it. So maybe we'll get him to come back and explain it to us whenever he gets a chance. Like, I have a very, very small grasp on exactly how to explain it to y'all correctly.
Decisions in setting it up, but he also had functioned as a physician during the operation of the center on several occasions and had examined patients and given them contraceptive advice. The evidence showed that Mrs. Griswold had taken case histories, had discussed methods of contraception with married women who came to the center, and on one occasion had given contraceptive materials to one of the women. There was testimony of 3 married women who had come to the center, had gone through the procedure which I have described, and were given contraceptive materials and thereafter used them. The defendants were convicted, sentenced to a fine of $100 each. Appeals were taken to the Appellate Division and the Supreme Court of Errors, which affirmed the convictions. The appellants at all times sentenced with a fine of $100 each. Yes, in the case of a doctor, the right to the license to practice medicine may be involved. Now,
Do you make any constitutional distinction between the doctor and the director of the institution as far as
no, Your Honor, we do not. The doctor's right is a right to engage in the practice of his profession as a property right, and we think that an equal...
So, Richard, this isn't actually a clip. We're listening to the full oral arguments for Griswold v. Connecticut. They're available on OYAs. I'm sure there's been YouTube videos made of it. I normally speed oral arguments up just a little because I know they run slow, but since I'm using them, they don't have a speed up version, which is why it's kind of a little bit of a slower pace than my normal stuff. So,
property right to engage in an occupation exists in the case of Mrs. Griswold. In addition, she was an assistant to the doctor, so she comes in with under the rights that pertain to the doctor.
You don't claim that because he is a doctor, he has a peculiar right over and above another individual to give this information?
Well, we do claim, Your Honor, that the operation of the statute is to violate his right to practice medicine in accordance with scientifically accepted principles. And in that respect, the fact that he is a doctor does make a difference. But the initial constitutional right with which he starts, the right to practice a profession or the right to engage in an occupation, it seems to me to be the same in both cases.
Yes. So that if the director had no doctors, she could have done this same thing, conducted this same kind of a clinic.
Yes, I think so. Now,
that's assuming the scientific validity of what she was doing. Assuming the required operation of doctors is not approved, she might be in a different situation.
yes. I mean, there would be questions of whether she was licensed.
hold on. Let me pause this and see if I can put this up here without getting restricted. It'd be like that sometimes, but hold on. Let me delete that. Let me, dang it. Sorry, source, window capture, add, Google, add source, and sorry, y'all, because I'm going to try to get this to where y'all can read the subtitles, because I know it's like hard to hear sometimes, and that gets very, very frustrating for people. So give me just a second. I apologize. But I know it'll make it easier for some people, especially because they're like very soft on some of it, but they'll actually have the full transcript on here. So maybe make it just a little bit easier for everybody. See what I can do. Okay. I hate it here. Hold on. Give me one sec. Okay. Sorry, I'm slow, guys. I really do apologize. No, that's not what I wanted to do. I wanted to crop this. Oh, of course. Because of course. Okay, well, this is just going to look funky, but at least maybe we can see some of it a little. There it goes. I hate this thing. Sorry, they have changed everything on TikTok Studio. I just got an update today, so that's why I'm like kind of struggle busting it over here. Now let me see. I'll just play while we're waiting. Give me 1 second.
To practice, but assuming that she was operating in the same manner as the doctor, I would see no difference. The major interpretation of the Connecticut statute is not in dispute either.
Professor, I'm sorry. Let me get back here. I gather, looking at your brief at page 9, that this exclusion of sales for the prevention of disease is read into the fact that the statute deals only with use for the purpose of preventing conception. Is that it?
Yes. In addition,
I mean, has there been any court decision or?
Not in Connecticut, Your Honor. The Massachusetts courts, which have a somewhat similar statute, have interpreted their statute as not applying to the sale or use. That doesn't apply to use. To the sale of contraceptives for the prevention of disease, and the Connecticut courts have cited with approval those Massachusetts decisions, so that we say that in effect the Connecticut courts have taken that position, but there is no direct ruling by a Connecticut court on that point. That's correct.
Well, wouldn't you, on the strength of that, wouldn't you have had a rather compelling equal protection argument? If the Connecticut court's gone that far?
And they are on sale.
Well,
you mean that
just trying to find out why you haven't made an equal protection argument, which on the face of it seems to me might have considerable merit.
Well, I wasn't participating in the case at an earlier stage, Your Honor, but the equal protection, there are differences between married and unmarried persons and between the use of devices for preventing conception and the use for preventing disease. And it's conceivable that the state legislature could validly make discrimination between them in some situations. I think we do. I think we will satisfy your suggestion for an argument under the Equal Protection Clause in the sense that we do argue that the discriminatory nature of an application of the statutes are one of the reasons why they are arbitrary and unreasonable under the Due Process Clause. But we have not made an argument that it is unreasonable to leave out the use for the prevention of disease as an equal protection argument. It seems to us it's inconsistent with the whole philosophy of the statute, but we have not made it as an equal protection argument.
Well, it just struck me. If it has merit, a narrower constitutional ground that would dispose of the statute, which is what you want to do.
Well, it would dispose of the statute, Your Honor. That's correct.
Mr. Emerson, are these devices on sale in drugstores?
There's nothing in the record about that, Your Honor. The question was asked about that at the trial, and the evidence was excluded. I can, however, say that from my own information, they are on sale in the drugstores for the prevention of disease. They are, at least technically, not on sale for any other purpose.
Openly and avowedly, they're on sale, not secretively.
They're not normally on display, Your Honor. They're under the counter, but there's no problem of obtaining them if you ask for them.
It's not done
now, certain devices must be sold on physician's prescription, of course, and can be obtained only on prescription from a physician. But others, which do not require such a prescription, can be obtained without at the drugstores.
I'd like to ask you a question in connection with Justice Brennan's question. I can understand an argument from my own constitutional ideas based on equal protection. It seems to me what someone has done here deliberately is try to force a decision on the broadest possible grounds of the meaning of due process, speaking as a matter of substance, and to have us weigh facts and circumstances as to the advisability of a law like this rather than leave it up to the legislature.
Well,
as I understand it, however, you're abandoning your idea, any argument on equal protection. As such.
We have never made any argument on equal protection as such, Your Honor.
You pitch it wholly on due process with the broad idea that we can look to see how reasonable or unreasonable the decision of the people of Connecticut has been in connection with this statute.
We pitch it on due process in the basic sense, yes, that it is arbitrary and unreasonable, and in the special sense that it constitutes a deprivation of right against invasion of privacy. The privacy argument is a substantially narrower one than the general argument.
How's that, Richard?
That's correct. They're both due process. They're both due process.
Nothing but due process. No other constitutional provision.
Well, we also argue the First Amendment, Your Honor. We have a First Amendment argument. We argue the Ninth Amendment as part of the privacy. Well, the Ninth Amendment wasn't clearly raised below either, Your Honor, and in that sense we didn't feel that we could pitch it squarely on the Ninth Amendment, but we refer to that as a basis for the right of privacy. That's correct, Your Honor. Yes. And
you expect us to determine whether it's sufficiently shocking to our sense of what ought to be the law, because this applies to married people only.
So just as a frame of reference, if you're wondering, at this point in time, they had only been recording oral arguments for a couple of years. So like, they don't have the microphone set up they have today. They don't have everything, which is why the background's a little skewed. I'm going to work on this for next time to make it fit so I can also let y'all see like what they're saying and how to fit everything in. But this is Griswold v. Connecticut. This is a pinnacle case for women's rights and the right to privacy. And this is something that is fundamental that we should be talking about. We should know what it was, we should know what it did, and we should know how it influences cases going forward. Let me go ahead and start back in on this. Sorry, guys.
Yes, Your Honor, but it is not broad due process in the sense in which the issue was raised in the 1930s. In the first place, this is not a regulation that deals with economic or commercial matters. It is a regulation that touches upon individual rights, the right to protect life and health, the right of advancing scientific knowledge, the right to have children voluntarily, and therefore we say we are not asking this court to revive Lochner against New York, or to overrule Nebbia or West Coast Hotel.
Like you're asking us to follow the constitutional philosophy of that case.
No, Your Honor, we are not. We are asking you to follow the philosophy of Meyer against Nebraska and Pierce against the Society of Sisters, which dealt with Meyer against Nebraska.
That's the one that held that was unconstitutional, as I recall it, for a state to try to regulate the size of loaves of bread.
No.
Keep people from being defrauded, was that it?
That was the Lochner case, Your Honor. Meyer against Nebraska held that it was unconstitutional for a state to enact a law prohibiting the teaching of the German language to children who had not passed the 8th grade. And Pierce against the Society of Sisters held that it was unconstitutional for a state to prevent the operation of private schools in the state. And those were both due process cases, were decided as due process cases. And the Aptheker case, well, I would bring within this rule the Schwari case, Schwari against the Board of Bar Examiners, and the Aptheker case, most recently, all were due process cases which related to individual rights and liberties. And we distinguish those from the cases which involve commercial operation like Lochner against New York and the West Coast Hotel against Parrish. We make that very definite distinction.
Well, let's see. Aptheker or other underpinned on the concept of overbroadness which went too far?
Well, it was a due process. It was a
that's
very.
due process. That's due
Yeah, but
process.
that's the same kind of due process argument we're making here.
In other words, that this, however constitutional, a state may enact a statute on this subject, to go so far as to reach married couples goes too far, and in that sense, the statute's overbroad.
That's right. That's right. It's an undue breadth argument, very similar to the Aptheker argument. And Mr. Justice Bach, when I get a little further along, I think I will.
All right, Law, you are back. You got anything for us yet? I had some hot takes, but I'm sure you probably know more about this case than I do. So, any thoughts yet?
Hold on. My Wi-Fi is being goofy.
No
Just
worries.
a second. All right. We'll see how that goes. So you asked about demur. Demur is an old-timey word. Right now, we call it failure to state a claim upon which relief can be granted. So 12b-6. So it's just a fancy word for basically saying even if you accept everything they say is true, there's no actual legal controversy here and no relief that the court can grant. So that's what that means, just a fancy old-timey word for 12b-6 motion.
Gotcha.
And then, you were asking about the disease prevention. Remember, we're talking about contraceptives, so not just birth control, but condoms.
Oh,
So
Jesus.
back
I
at
didn't
this
even
time,
think of that.
condoms could be sold for disease prevention.
My God. Sorry, go ahead, Law. I apologize. Oh, we were cutting out. My bad.
It's my country Wi-Fi. So condoms could be sold for disease prevention, but God forbid if you use it as a contraceptive. So that was the state of the law at this point. And then there was some back and forth about, well, why didn't you do equal protection? Why didn't you do equal protection? One is, I'm not sure it was raised at the lower court. So if you don't do it at the lower court, then you can't preserve it for appeal in the higher court. But then secondarily, too, is when you're trying to move mountains, sometimes it's better to, take them one small chunk at a time. And so I think the Griswold and the doctor were very careful to not try to get too much at once. Like when we look at Roe started off with a trimester framework, which kind of turned out to be unworkable, but it was something that it was least cognizable. And then we went to Casey, which, provided some additional clarification. So it's, if you're trying to create big earth-shaking precedent, you don't want to try to bite off too much at one time.
Gotcha, that makes sense. So the next case that I'll be doing on Wednesday is Eisenstadt v. Baird, which is actually, so this case, everybody talks about it, but this case only did it for essentially married people, married women. So Eisenstadt is the one that said, nah, single women can do this too. So it's very interesting to kind of look at the case line of where it goes. We had the Griswold, the Eisenstadt, then Roe, Planned Parenthood, and then Dobbs. So yeah, thank you for that, Law. I appreciate you.
Also narrow the issue down somewhat further even. That's correct, Your Honor. That's correct. Yeah.
Sorry, it's just inaudible.
Yeah. That's correct, Your Honor. That's correct.
Now you're going to come and tell us why it is it's overbroad as to married couples.
Yes. Oh, yes. Let me first say one further thing in a preliminary way. With respect to the interpretation of the statute, the Connecticut courts are clear that the use statute prohibits, by criminal process, any use of contraceptive devices for prevention of conception. And there is no exception to that statute. It applies to married persons, to married couples. It applies to a woman whose health is such that a further pregnancy would be dangerous or perhaps fatal. It applies even though the prescription, there is...
I'm going to point it out again. How eerily familiar this should sound to anybody living in a state that decided after Dobbs, fuck them, that's why. I want to remind you how eerily similar this argument they're making just about contraceptives sounds on the arguments, I guess if you are pro-choice or vote pro-choice, whatever you may be, to what's going on right now for women in states that have lost that protection. This is less than 100 years ago. They're arguing about whether married couples can prevent a future pregnancy. Like married couples, this doesn't even apply to single women at this point. They're arguing about whether married couples, and more specifically married women, can prevent a pregnancy. I guess married men with the condoms too, like, to be fair. But like, that's what they're arguing about. Like, you know, it could, like, she can't have another baby. They couldn't even have contraception. Like, I just want y'all to realize how insane this sounds. Sorry, y'all. I just had to go on a tangent.
There is a doctor's prescription based on scientifically medical grounds. It applies without exception. On the other hand, as I indicated, it is not an offense to sell these same devices or to use them for purposes of preventing disease. And the accessory statute prevents a doctor from prescribing them for prevention of conception and prevents their sale for prevention of conception. Now, the Connecticut statute is a unique statute. There is no other statute dealing with this problem that makes it a criminal offense to use contraceptive devices. In that respect, it is totally unique. The only other statute, which is somewhat comparable, is the Massachusetts statute. The Massachusetts statute prohibits the sale or giving away or display of contraceptive devices for prevention of conception. It is different in that it applies to the sale, not the use, but it is the same as the Connecticut statute in that it has been interpreted to apply without exception. It applies to married persons, on doctors, physicians, and so forth. Now, the statutes are collected in the appendix to the brief for the amicus brief for the Planned Parenthood Federation.
Said it at the beginning. They were
I will
going
not
after
go into them
doctors,
further
not
except
necessarily
to say
people.
that there is no other statute, either state or federal, which has been interpreted in this way or applied in this way, either by express language of the statute or by judicial interpretation or by application of the executive officials charged with enforcement. All the other statutes allow at least the use of contraceptives and for purposes of preventing conception and their sale on doctor's prescription or through some pharmaceutical arrangement or something of that sort. There are no others like the Connecticut statute or the Massachusetts statute.
Are you emphasizing that on the ground that the state is without power wholly to prohibit the use of contraceptives, that due process?
I want y'all to notice that total flip-flop in the states, though. I'm sorry. I have to be the one to say it. Like, this is Connecticut and Massachusetts that they're bitching about right now, being like, no, you can't do shit with it. That, just the irony, I guess, for me. The irony.
That's forbidden.
They have the power to prohibit as to married couples within the marriage relationship.
Well, this is actually a good question for you. These old cases, I have no idea of any sort about the judicial theory of the courts. Was there anything different we were seeing at that time?
I mean, a lot of misogyny and racism, but besides that, it was a slow march towards recognizing. How I would say it is the principles that are enshrined in our Constitution exceed what I think the scope of that our founders actually applied them to, and we see that with, slavery and women voting and things like that. So the principles that are there haven't changed, but our society's understanding of who the principles apply to have changed. And it took a long time, and this wasn't that long ago. I mean, we're talking 75 years ago, that these cases started recognizing that and we saw this with Griswold and its progeny, which you're going to be covering. That okay, first we're going to say, well, the government has no interest in regulating a married couple's child plans, and then we're going to say, okay, well, then it doesn't have any interest in regulating single women's child plans. So it's a slow march. So there isn't one overarching philosophy, but the Berger Court was known for taking a lot of progressive actions towards applying those principles. So I don't know if that answers the question, but that's kind of my take on how we went from where we were to where we are, and in some cases are kind of backsliding.
Yeah, so probably one of my favorite justices, William O. Douglas. He's a big crusader for privacy and, limiting what motherfuckers can just get into your business for. But wait, you said Berger or Warren? Oh, sorry, Berger or Warren? You said Berger.
I said Berger. I meant Warren. Warren Berger is a person, but I get them confused. But yes, you're correct, Rob.
The Warren Building.
As a Minnesotan, that's where my brain goes.
I know. But yeah. So I just find these cases so interesting and sort of the evolution of. And it just, like, to your point, yes, somehow we're sliding back into this, somebody said in the comments, and they were totally right, is this when America was great? When we were having to figure out whether married couples could, not have a baby if they didn't want to? That just seems so wildly insane to me. So I guess what you're trying to say is maybe the judicial styles didn't change much, but the evolution of the applications of the court did.
Yeah, I mean, we've always had more conservative justices. Scalia was kind of granddaddy of textualism and originalism, but we've always had some, and then we've had some that were far more consequentialist and far more outcome determinative. So in that sense, those philosophies have always existed, but the way that they were applied has definitely evolved over time.
Thank you for that.
Yes, Your Honor.
That's the basis of your argument, that a state cannot pass a law which forbids all people to use contraceptives, and it's forbidden to do so by due process. The due process clause.
That's correct, Your Honor. Yes, and also the First Amendment clause. In this case, at least, the First Amendment.
Use is not speech, is it?
No, it isn't, Your Honor. That's a different argument.
Mr. Emerson, maybe I misread your opponent's brief, but if I don't, there seems to be a little difference of opinion between you as to what you've just told us. I'm referring to page 9 of his brief, in which he tells us that some 30 states have laws on this general subject, laws of one kind or another. And of those 30, the laws of Massachusetts, Minnesota, Mississippi, Missouri, Nebraska, and New York would be violated by the facts in the present case.
Yes, Your Honor, I disagree with that statement. Only Massachusetts law would have been violated by the facts of this case. The Minnesota and the New York laws prohibit sale except on a doctor's prescription, and the wording is for use for the cure or prevention of disease. They can be sold in Minnesota and New York on doctor's prescription for the cure and prevention of disease, but the court in New York, in the Sanger case and in later cases, has interpreted that language to mean for the purpose of promoting general health and well-being, so that New York does have birth control clinics operating in New York City, and the New York and the Minnesota statutes similarly are classified as statutes allowing sale on prescription of physician for purposes of general health and well-being. The Mississippi, Missouri, and Nebraska statutes do on their face sound like the Massachusetts statute. They are statutes prohibiting sale, but they have never been interpreted that way. Well, I'm not sure there are any court decisions. They have never been applied that way in those states. And there are in those states birth control clinics operating either by the government or by Planned Parenthood, so that although on their face those statutes would apply, they have never been utilized in that way, and the center would have been allowed to operate in those states.
You're telling us that they're dead letters, that they're not,
that's right,
as a matter of administration of the law, they're not enforced, but you're kind of reaching the basis on which this court disposed of Poe against Ullman, which I suppose didn't please you very much, did it?
Well, Your Honor, many.
Do you have any background on the Poe case they keep mentioning? I'm unfamiliar with that. I don't know if you know it off the top of your head.
Not off the top of my head. Give me a second.
Just let me know you're ready. I'll play it for now.
Many of these statutes started out with language similar to the Massachusetts statutes. As far as I know, there were no other use statutes, but have been interpreted as the federal statutes have, not to apply except to unlawful uses, in effect.
How about the federal statutes? 18 United States Code 1461 and 62?
Yes, those are statutes which prohibit
having to do with the mailing of them.
Mailing or transportation in interstate commerce or importation of articles designed to prevent conception. They were interpreted from the beginning, the leading case which we cite is United States against One Package, a decision of the Second Circuit in 1936, which held that they prevented only the transportation of contraceptive devices for unlawful purposes, illegal abortions or unlawful purposes, and did not prevent their transportation where those purposes did not exist, so that contraceptive devices are sent through the mails now, do move in interstate commerce, and that.
Wow. How familiar does that sound, everybody? Just curiosity. Again, if you're living in a state that's highly regulating after Dobbs, you're probably more than familiar with this, or at least should be, that certain states, including my AG, are trying to attack sort of like mailing of like abortion pills. God, this is almost creepily eerie. Like, it's almost scary. I haven't watched this in forever, but watching it now, creepy. Poe is a predecessor to Griswold that was dismissed as non-justiciable because CT was never. I'm mind blanking. Log. Can you tell me what that means? Sorry,
Yeah, I'm sorry. My Wi-Fi is really bad.
It's okay.
So Yeah, it was essentially it was a case attacking the same law, but Connecticut never actually enforced it. So it was dismissed as non-justiciable because there was no live controversy. But here it was actually enforced against Griswold and the doctor. So they actually had a live case in controversy.
Got you. Okay, CT meant Connecticut. I was like, wait, what the hell? Like, I feel like I should know this, and I didn't
You
realize
got to learn your postal
state.
codes.
My bad. Sorry. I'm tired. We'll just chalk it up to that.
That language, which could have been interpreted the way the Massachusetts legislation was, has not been so interpreted. Your Honor, it depends on what ground we prevail. If we prevail on the privacy ground, that would probably end only the Connecticut statute, because the Connecticut statute is the only use statute. If we prevail on the further basic due process ground, it would, I think, end the Massachusetts statute, because that ground holds it arbitrary to apply any such statute in the married with respect to married relations.
What about the federal statute?
The federal statutes would continue as they are. They have been interpreted so that they don't raise any of these questions, and I would say that is true of the of all the other statutes, so far as I'm aware.
How have the federal statutes been interpreted, did you say?
They have been interpreted as not to raise these questions because they don't prevent the shipment of contraceptives for use by married couples in within the marital relationship.
What cases?
Yeah.
The United States against one package is the leading federal case on that, Your Honor. It's cited on page 24 of our brief.
This court?
No, that's the second. That's the Second Circuit.
Back in 1936. Is that right?
1936. Yes.
Nothing in this court.
There's been nothing in this court, I think, Your Honor.
Yeah, very much old movie speech patterns.
The privacy
Pulper.
ground, when one process has prevailed, and the due process ground another. The privacy ground, privacy, the underlying precedent of the Constitution within limits. You're entitled to let alone.
Well, you're correct. You're correct, Your Honor. I was speaking rather broadly there, because it's quite true that many of the privacy arguments would apply to the sales statutes. Some of them don't, and therefore you don't have as clear-cut a privacy argument with respect to the sales statutes. I should have put it in those terms. I was stating it too generally.
Well, I wonder, Professor Emerson, if this goes off, if you were to prevail on an abstract or overbreadth ground, why would that settle anything except that this Connecticut statute is overbroad? Why would that settle necessarily the constitutionality of the Massachusetts statute?
Well, because, Your Honor, the question is, why is it overbroad? The reason it is overbroad is because it denies rights to married couples that should not be denied, and therefore that would be true equally of the use statute or the sales statute, I think.
That should not be denied in the judgment of this court.
That's correct, Your Honor.
Is there any constitutional provision that says that?
We're relying on the due process clause.
Is there any other constitutional provision on which you could possibly rely for it?
We rely on the Third, Fourth, and Fifth Amendments insofar as they embody a concept of the right of privacy, Your Honor, which are incorporated in the 14th Amendment, since this is state legislation.
swear to God, that is still Hugo Black, and he was talking perfectly fine just a second. Were they just like running around in the courtroom back in the day? I have no idea what these motherfuckers are doing, but geez.
They might have actually been running around with like a corded mic between the justices.
Oh my God, I never thought about that. Holy shit, that makes... Damn it, Law, you're just hitting it out of the park tonight, and I'm just like on that airhead shit. Blame it on being tired.
It could very well be, Your Honor. We certainly the Ninth Amendment meant to reserve some rights to the people, and if there's any right that you would think would be reserved to the people and which the government should not interfere with, it would be this right, yes.
Do you have any data as to the breadth of the use of these devices back in the late 18th century when the Ninth Amendment was adopted?
No, I'm not familiar with that medical history, Your Honor. Methods of contraception have been used for ages of various types, and what state of the art was in 1879, I'm not exactly sure.
I think we can... It is true that there's been a good deal of technological development in this area in recent years, isn't it?
Yes, there has, Your Honor. There has been a very substantial development, particularly with respect to intrauterine devices, which and also the oral contraceptives, the pills.
Now that I've interrupted you, you've told us that in Connecticut...
Must mean diaphragms.
The sale of
like,
these devices is not molested because they're sold for the prevention of disease. Is this true about all of these devices that are covered, that each of them has the potential dual function of acting in a contraceptive capacity and as a prevention of disease, or only with respect to some of them?
It's probably only true with respect to some, but some get by under the term feminine hygiene, and others I just don't know about, but they are all sold in Connecticut drugstores on one theory or another.
Is there anything in the record to
Man, we
indicate
take the internet for granted.
the extent of the birth rate in Connecticut vis-a-vis the states that don't have such laws?
Well, there's so many other factors involved, Your Honor, that would be hard, I think, to isolate this. The Connecticut birth rate is, I believe, in excess of that of the nation. I think at least the increase of its population from 1950 to 1960 was something like 26%, and the rest of the nation, the population was...
Let's talk about that real quick. Increase of its population from 1950 to 1960 was something like 26%. So, again, just eerily familiar. You know, just make them have babies, like, cause fuck them, that's why. We don't care if they want kids, have kids, any of that other shit. Cause fuck them, that's why. Just saying.
With 18%, but that may involve a lot of mobility between states, people moving between states and so forth. Doesn't prove either way, I think, Your Honor. That factor cannot be really isolated that way, I think.
Are there any statistics that indicate that Connecticut people have been suffering because of inability to get such things?
There are no statistics, Your Honor, but the effect of the operation of the statutes is that people who are too poor to have private physicians or too uninformed to know about these matters do not get the services. And there's no doubt whatever that there would be room for an important work in terms of giving people advice and information and instruction with respect to contraceptive services when they wanted it in Connecticut.
But this one's not a question of advice, is it?
This involved more than advice, Your Honor. That's true. It also involves some.
You also make the First Amendment argument based on advice, don't you?
First Amendment argument is based on the advice aspects of the case.
But there was more than advice here, wasn't there?
There was, yes.
There was furnishing.
There was, yes. There was, I would say, examination of patients, prescription of a device, furnishing the device. All of those would seem to me action and not within the First Amendment protection. In addition, there was advice to married women generally, and the aiding and abetting statute includes not only assisting and abetting but counseling. And that part of it, we think, would make the statute void on its face.
Well, you got to cover in your argument why these defendants can
really
should assert
familiar.
the rights of the married people on.
I cover that, Your Honor. Yes. One major reason is that there is no violation of the accessory statute unless there is a violation of the principal statute, so that the appellant's rights.
I'm going to ask you a hypothetical law. Do you think the people in these, like my state, just sat down and looked at Griswold v. Connecticut and they're like, that's what we need to get back to. That's what we need to do.
The good old days, forced birth.
Just, it's almost scary how intensely familiar it is. So I'm like, holy shit, this is scary.
I like what Rob said earlier, is time is a flat circle.
For real. Well, hopefully the 11 people in here are enjoying this. I think these are really important. And if you're interested in supporting women's rights, or even if it's not the women's rights, just your fundamental right to, do what you want with like your own fucking body and not have the government tell you what you can do and interfere with your decisions. These are cases you need to be watching. I know that they're focused on women, but these are important privacy lines for everybody. So just to throw it out there. Teddy, hey, what's up, baby?
Are the same as the patient's rights, because if the patients were acting constitutionally, so were the appellants. But there are other reasons. I think there's no real problem about that, Your Honor.
Mr. Emerson, do I understand you that if a couple goes to a doctor and gets this information that they violated no law, but if they go to a clinic they have?
Just
No,
as a side
Your
note,
Honor, they would have violated the law if they go to the doctor.
in 1965, I don't even know if men are in the delivery room at that time. I can't speak to that, but I'm going to say it's less common than it is now, just for clarity. But they need to go to the doctor with you if you want to protect yourself from getting pregnant. Imagine that shit.
I think you're absolutely right.
I was pretty sure I was, but like I wanted to be careful because we're starting to get into like more women's rights, civil rights. So things may have been a little bit changed, but it's not that far from the 50s where they're kicking you out into the waiting room. So
Doctor, but the law has not been enforced against private practitioners, as this court, at least this court so held in Poe against Ullman.
It's never been enforced against anyone, has it?
Yes, it has been enforced against the clinics since 1937.
Relief judgment was all.
Well, no, Your Honor, the initial case, Spade against Nelson, was a criminal case against a doctor and a nurse who were operating one of 9 clinics that were then operating in Connecticut. That was 1940 was the decision of the Connecticut State.
Isn't that the one? Isn't that the one that was now crossed when it came back?
That's correct, Your Honor, but it wasn't prosecuted because the clinics closed down. The Waterbury Clinic, which was the one involved, closed down, and the other 8 closed down, and no clinic has opened in Connecticut since then.
It wasn't closed down when they charged them, and it wasn't closed down when they got the final judgment of the Supreme Court of Connecticut, was it?
It went up on the demurrer. of course, so that when the Supreme Court of Connecticut ruled that the statute should be interpreted as applying to this situation, even though there was a doctor's prescription, that settled the legal issue so far as Connecticut was concerned, that it was a violation, and at that point clinics no longer operated. I'm not exactly sure when it actually closed down, but the result of the Nelson case, even though there was no ultimate conviction, the result of the Nelson case was to close down all the clinics, and this clinic was closed down, or at least the participants were arrested within 10 days after it opened.
But how can we say that that this law is interpreted by your courts not to apply to doctors who do the same thing that this clinic does? Where in your law or in your decisions can we find that?
No, it isn't. The interpretation, there's no difference in the interpretation, Your Honor. The law would be interpreted to make it a criminal offense for a private practitioner to do this, as well as a physician in the clinic.
Well, that's what I understood, but also I understood you to say that a person of means could go to a doctor and get this information because he has the money to pay for it.
That's right.
A poor person could not do it. Now, what do you base that distinction on?
That's the basis of the Poll case, Your Honor. It isn't enforced against doctors. It isn't enforced against private practitioners or individuals.
Does the state concede that?
I'm not sure, Your Honor.
Well, you must have had some experience with it up to this time. What have they said about that as it's gone through the courts?
Well, Your Honor, I was not in the earlier stages of the case. I'm afraid that you'll have to leave it. You'll have to ask them.
Very well.
At least it's not in the. It's not. I gathered from the talk about equal protection before that issue is not on the record. It's not developed in the record, and an equal protection argument is not made.
We have not made an equal protection argument as such.
And the record doesn't show whether or not the state enforces it against the private doctor.
No, the record does not show that, but that was the basis of Poll against Ullman, Your Honor.
Yeah.
Correct me if I'm wrong, Law, but Roe, when Ruth Bader Ginsburg talked about Roe, she said that she would have preferred it been argued under equal protection, correct?
Yes.
I wonder, I'm wondering just out of sheer curiosity, like why they would, because we're seeing the backlash of those things now, right? Like we're seeing the backlash of things not being argued under equal protection and things like that. So I'm wondering, like, is there a reason why they may not have approached it that way?
For this one, I think it was just not biting off too much. They were going with what would have provided them the most narrow relief as it was to married couples. If you went with equal protection, then you're opening it up for everybody, and that might cost you a couple of justices enough to not get a decision in your favor. But if you can take kind of these, old fuck justices that think that, all these loose women are running around, blah, 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 and instead confine it to, the sanctity of privacy in the marriage, they're more likely to go along with that type of argument. So it's all about counting to 5. You need to get those 5 justices to get that. So I think that, and then we saw, with the next case you're covering is, that now they're expanding it. So well, hey, what's the difference between the privacy of a married couple and the privacy of a individual woman? And so I think these are the stepping stops. This is when you do smart litigation to not try to take down the whole building at once. You just remove it one brick at a time and get progress that way.
That makes sense. I was just curious because it just feels like this whole thing, like, things just keep repeating for me. Again, fatigue. But I was just curious about that. I was wondering why they may not. That makes perfect sense. Thank you so much. All those loose women running around. What's crazy is, while they may not have, I'm going to say it like this, not for women specifically, but for men, like, while nobody may have thought, and for probably quite a few women as well, it's just probably not as public, they were still running around. Just didn't talk about it. Like, it's more open now, but I don't think times have changed that much. I mean, maybe different than
No,
1850.
I'm with you.
1960, nah, they were still doing their shit.
Are you coming back to your First Amendment argument? If not, I wanted to ask you a question.
Well, I'm not getting far on any of my arguments, Your Honor. But I can't guarantee I'll get back to the First Amendment. No.
Well, I withdraw the question.
Let me just outline the argument on due process. It proceeds along two lines. The first is that this is an enactment of a principle of morality, which has no objective relation to any material welfare, and
why wouldn't it if it relates to morality?
It had to material welfare. I said, Your Honor. It's.
You mean money welfare?
Well, or measurable welfare. It's a moral principle. It's a religious principle that's being enacted into law. That it is immoral to use contraceptives even within the marriage relation, and therefore can be made an offense. That is the aspect of the statute we're dealing with at this purpose.
And
I say that is purely a moral judgment which cannot be measured by objective circumstances. There is nothing harmful about contraceptive devices, either to the individual or to other individuals. They are useful and important for solving many medical problems. The woman who cannot have another child without incurring ill health or death has no other solution to that medical problem, no other effective solution than the use of contraceptive devices or abstinence. Consequently, there is no objective basis for the statutes in this respect, except the moral principle. And we say that the state cannot enact such a abstract moral principle unless it is one that conforms to current community standards, and that this statute does not. That the government and the government programs are widespread at the federal, state, and local level in which contraceptive devices are used. The Congress of the United States last session appropriated funds for the District of Columbia to create birth control clinics in the District of Columbia using contraceptive devices.
How do you measure community standards?
The material on that is developed.
That's something interesting that they just said, that the District of Columbia had, like, Congress had appropriated funding for them to set up clinics there. I want to point that out for everybody to keep that in mind. Not saying it's going to factor in anything, but just my brain's working. Maybe.
At some length in our brief, Your Honor, but the point I'm making now is that if the government, it can scarcely be said to be contrary to current community standards if the government itself does it.
Was this a national standard?
Well, this was the federal Congress. Yes, I think this is a case. I realize this problem of the national and local standards, and I hope I don't get involved in that at the moment. But
I don't understand why you're saying Congress has one standard it thinks should be adopted. The people of Connecticut would be tied down to that standard. within their area of power to legislate.
Well, Your Honor, that's in the first place, there'd be a number of people moving in and out of Connecticut that would be affected, I think for the same reasons that prevail in the obscenity cases. The national standard is the one that I think should be applied here. However, let me simply take a moment to develop the other phase of the due process argument, which is the reasons why we think that using the strictest standards, this nevertheless falls under the doctrine that a law cannot be arbitrary or capricious. And
you insist that that's what we got to decide, as long as I understand it. That we've got a right to set aside state laws that we think are arbitrary.
God,
and
Hugo
capricious
Black's like
in our
8,000
judgment.
here.
in the field of individual liberty, Your Honor, in a field where the laws not only affect important individual rights, but are quite inconsistent and arbitrary in their application. The laws in relation to this, to contraception and abortion and sterilization make no sense whatever.
Suppose one agrees with you, as I might. Does that give me the right to say that Connecticut can't have a different idea?
No, Your Honor, no. It's not. Obviously, we don't press the issue that far. We do say that in the field of individual liberties, and in the field where the individual is entitled to some private sector against which government is forbidden to intrude, in that narrow area, unless the state can make an overwhelming case for intrusion which destroys the right to decide whether to have children voluntarily, whether to be able to maintain health and the very life of the individual, when the state makes decisions which affect those rights, then unless it has an overwhelming case, and I submit that here it doesn't have that kind of a case, and I have not had time to outline the reasons or to catalog the injustices and absurdities of this statute, but they're set forth in our brief. I also have not had time to discuss the privacy argument or the First Amendment argument, but I do want to reserve a few minutes for rebuttal.
You may, Mr. Anderson. Mr. Clark.
Mr. Chief Justice, if it please the court, actually the issue that this court is being asked to decide is not a new issue here. It should the case of State versus Sanger from New York, and should the case of State versus Gardner from Massachusetts, decisions of this court be overturned. In both those cases, this court was involved with a situation where clinics were being run in which contraceptives were supplied to people to be used as contraceptives, the same factual situation we have here. And in both cases, this court held that this was not a federal question. This was a question solely within the responsibility of the state legislatures, and it was not a question to be entertained by this court. Now, they involved sales, if Your Honor please. But the Connecticut court in the Tileston case has...
So if anybody was red flagging on the name Sanger, that was dropped a few times. It was a 1918 case, I believe, out of New York. I just had to double check it. But yes, it was Margaret Sanger they're talking about. Sorry, just fun fact for the audience.
has interpreted the Connecticut statutes, this particular statute, the interplay of these two statutes, as applying to both the user and the provider of the material. And it's conceded by all, and I think it was conceded by Mr. Emerson here today, that the statutes, in their breadth, with the accessory statute, apply to the situation of sale or providing or disseminating or however you want to call it.
That's only for the forbidden purpose.
But, if Your Honor, please, there's no other purpose in this case. We have
Well, if in fact they're used for used or provided for the prevention of disease, as I understand it, that's no crime.
Well, now this is an interesting thing, if Your Honor, please, because we have the case in Massachusetts where this argument was made.
Now, what about Connecticut?
Connecticut has no case at all on the subject.
Well, I understood from what Professor Emerson said, that while it was not directly decided, there were indications in some Connecticut court opinions that this statute would not reach that
Well,
situation.
there may be, I can't recall them at this time, Your Honor, please. I might say this, that it has been held both in the brief and here today.
Were they just going to the Supreme Court drunk at this time? Like, I'm sorry, hearing somebody say, like, I don't know about that, like, when it's, like, quintessential to their argument is crazy to me.
Yeah, and I wouldn't put it past them.
That there have been no convictions under Connecticut law. Well, to that I might say that, of course, the Supreme Court of Errors of Connecticut only handles appeals.
And I don't know, as a matter of fact, whether sales take place, don't you?
Well, I am told that sales take place, if Your Honor, please. It's an under-the-counter basis. It's the same as sales of numbers take place.
They're illegal sales?
They're illegal sales. They're the same as a bookie selling a horse race. It's against the law. It's illegal.
Do you know of any police that ever done anything about it?
There have been convictions.
What, of selling?
There have been convictions, if Your Honor, please.
Drugstore selling?
Yes. Now, the thing is that, of course, there are no recorded cases on this prior to 1961, and the reason for this is that prior to 1961, the minor court system of Connecticut consisted of courts in many towns, several towns. You had a JP system in some places. You had municipal courts of varying degrees. With the circuit court system, all the minor courts, the minor criminal things, misdemeanors, certain felonies, came into being, into one place. And from now on, from 61 on, there's at least a possibility of more records being kept. Now, in all cases...
What about doctors prescribing? Are there any cases?
There are no cases of any doctors prescribing either. The only cases that have ever...
Has there been any prosecutions of
doctors
who have prescribed?
I have never heard of any prosecution of a doctor who prescribed.
Your theory on that is that that's because they're prescribing for the prevention of disease or not?
If Your Honor, please, it seems to me that argument is completely irrelevant, that they are not, in fact, prescribing for the prevention of disease. The prevention of disease is a completely irrelevant argument in that only certain of these devices could be used to prevent diseases. These devices are not in this particular case. But only certain devices could be used to prevent disease. Now, who could use the devices? Since Connecticut has laws against fornication and adultery, only married people could use these devices. In order to get married, you have to have a certificate that you're free from venereal disease. Therefore, you couldn't have the disease beforehand. The devices can only be used against venereal disease. This argument...
Sorry. Oh, so we're just going to act like people weren't out there running wild, cheating on people, and catching shit after they got married? Okay, brother. Okay, go off.
This is a time when, like...
Oh, sorry, Law. Go ahead.
This is a time when dudes, like, had full-on, like, double families, like, different families in different states. And, you know, they would be traveling salesmen. This is crazy.
That fucking part. That part. Like, get your freak on. That's fine. Do your thing. I don't care. But like, at a time where you couldn't even wrap it before you tap it, these devices absolutely prevented disease. And like, if you don't want to bring home like the clap to your wife, it's probably good to wear them. Just side notes. Public health announcement. Wrap it before you tap it. Thanks so much.
To prevent disease seems to me a ludicrous argument. It just
if Connecticut permits sale by drugstores or if Connecticut permits prescription by a doctor, it isn't because of the prevention of disease.
Connecticut does not, in fact, permit. That is the point. We cite in our brief, the other side pointed out that there was a letter to the late Professor Fowler Harper, who had represented the appellants in their case, and to the effect that
Never caught it before, but is there a reason they keep addressing them as professor? Like, it's just unusual, and it's like twerking my brain. Like, is there maybe just different time or?
Yeah, it would be if he was like a law professor at a university, it's just a title that you would use for a professor. It's, I don't know if we have. I think that it's not something that's probably commonly done now, but back then professors definitely wanted to be addressed by that, and it was fairly common to have them done so.
I got you. Yeah, no, it's noticed that the attorney that was representing Griswold, they called him that as well. So I was like, sorry, I was like, it was just, I just wanted to know if maybe there was a reasoning. So I had never noticed it before, and it just caught me, and I was like, hold on. I guess I wasn't listening well the first time.
I just applied for an adjunct.
Excuse me. So
the sorry. Hold on. Let me pause real quick.
Consumer Protection Division now.
Go for it.
I just applied for an adjunct professor job at my old law school. So if I get that, I'm absolutely going to demand to be called professor.
Yes. So please get me in. Thank you so much. I'll be taking no questions on the matter. Okay.
Pure Food and Drug, I think, was the title there. Concerning sales, supplying certain devices that might have been used, they claim. And they pointed this out. As a matter of fact, they pointed out in the Poe case.
Well, does this mean that, is it the state's position that a sale or advice represented to be to prevent disease would be a violation of this statute?
If Your Honor, please, if it could be honestly...
Well, would it or wouldn't it?
I don't think it would.
It would not be.
I don't think it would be if it in fact could happen, but I just can't see that it could happen.
This shit today.
Because I don't see that position. It's the devices.
Is the device which you're talking about here described in the record? If so, what page?
If Your Honor, please, a device that could be used for the prevention of disease.
I'm talking about this one. You said this one is not that kind. Is it described in the record? I won't ask you to describe it. Just want to see when it's described.
They are listed in the findings as exhibits. I think that is the only place it can be found in the record. That the particular things that were given to the particular married women involved in the case.
They're adequately described in the record. In each of the testimony of the women, they state specifically what devices.
That is correct. Yes.
So that we have a record of what devices. And
yes.
You're saying that those devices, which are described specifically, have nothing to do with devices that are sold or prescribed for prevention of disease.
That is exactly my point.
Correct.
That is exactly my point.
Mr. Clark, as I recall it, when...
Are they just going round and round to say birth control pills? But, like, I guess, I don't know. This is crazy.
The Attorney General was here in the Poe case. He disavowed any knowledge of any enforcement of this statute from a standpoint of devices for prevention of disease. Now, do you have information to the contrary?
I'm sorry, Your Honor, I did not get your question. I'm very sorry.
Well, when the full case was here, the Attorney General of Connecticut, as I recall, said that he had no knowledge of any enforcement of this statute so far as the selling of apparatus for the prevention of disease, and he admitted practically that they were sold in all the drugstores in the state. That's my recollection. I may be wrong.
I think that is undoubtedly the fact, Your Honor.
Yeah.
Things
Now,
have changed.
no.
No, they're sold under the counter. There's no question about it.
Yeah. Well, then why do you say to us here that there is enforcement of it, and there have been prosecutions here and there and so forth, if the condition is the same?
I say, if Your Honor please, that there is enforcement of it, that if there are sales, there are surreptitious sales, that there is enforcement in that.
Just a side note, everybody, less than 100 years ago, they're arguing this case. This is 1965, less than 100 years ago, when you couldn't say, I don't know, whatever fancy word they have for condoms and birth control in the Supreme Court, because it would make the justices blush. Or maybe this attorney should.
There have been criminal convictions of the statute itself. Now, perhaps my brother wasn't able to find them. Maybe I, in the position of prosecutor, was able to find a little better. But I did discover, and I wrote to the man who categorizes all the offenses, now that we have a statewide system in, and I find that there was in 1961 and in 1962 a conviction case that went through all the way on the merits.
All the way, what do you mean?
But that is a guilty finding, no appeal, the final disposition.
I see.
Charged on the merits. Now, I was not able to find out the name of the case or anything else because it's just a statistical basis. I could probably find that out. But there is at least one case 1 year and one case the next,
yes,
where somebody was convicted of violating the statute.
Very well. We'll recess now.
Okay, so there's another part to this argument. I was kind of explaining this a little bit earlier, Law, like back in the day, sometimes there would just be multi-day arguments. So did you have any comments or anything you wanted to weigh in on before we go to the next day?
No.
All right, let's hit it then.
Number 496, Estelle T. Griswold et al., appellants versus Connecticut. Mr. Clark, you may continue your argument.
Chief Justice, to please the court. In yesterday's questioning, there were some questions directed both to me and to Mr. Emerson concerning population and birth rates. In our brief, at pages 27 and 28, we cite the statistics that show that the birth rate in the state of Connecticut last year, for the 7th straight year, was on the decline. The birth rate in the United States is apparently also on the decline. And I would point out to the court that in the Reporter magazine of March 25th, 1965, there is an article entitled "Our Population, the Statistics Explosion," written in part by Richard M. Scammon, who was the head of the Census Bureau, that points out that the growth rate, or the birth rate in the in this country is actually on the decline, and takes great issue with the so-called experts, and it's using his term, of a population explosion. The tenor of his article is that this so-called fear that there will be no breathing room is actually a false use of statistics, that in fact, if you use the same logic that people of this ilk have been using in the past, the statistics would show, that is carrying out the same logic, that there wouldn't be anyone in this country by the year 2000.
Mr. Clark, what you're touching on now leads me to ask, what is the purpose of this legislation in Connecticut? Your basic argument in your brief, and so far in your oral argument, is that this is well within the so-called police power of the state of Connecticut. And what is its purpose?
Well, if Your Honor, please, I think its purpose is
to increase the population of Connecticut, or to impair its decrease, or is it what?
If Your Honor, please, I do not hold that it is to increase the population of Connecticut. I don't think that this is we could make this claim valid.
So what is it? What is the purpose?
I think it's to reduce the chances of immorality, if Your Honor, please, and I use the words immorality here in a broad sense. That is, in one way, to act as a deterrent to sexual intercourse outside of the marital relationship.
Well, the trouble with that argument is that on this record, this involves only married women.
That is correct, Your Honor.
So how can you make that argument?
Well, if Your Honor, please, I think that on this record, that the statute is a valid exercise of police power.
Well, for what purpose?
And if Your Honor, please, on this record, that there is a distinction, and there has to be a distinction between birth control and the use of contraceptives. That is to say that all contraceptives involve birth control. But in order to practice so-called birth control, one does not have to use contraceptives. And that the state is able to take this position and take this distinction. That there are, if it be said, well, should married people be allowed to use these devices?
Yeah.
Is not the state going too far? I think the state can answer to that there are other methods available to married people.
Well, now, for what purpose under its police power? Assuming we're dealing now with married couples.
Well, if Your Honor, please, going back, Connecticut in the Nelson case cited the Byrne case in New York, and one of the reasons cited by the Connecticut court and the Byrne case was that it would not be, as a matter of fact, it would not be improper for the legislature to consider that Connecticut, as any state, has a right to look out for its own continuation. This is the population argument. I personally am not too happy with it. But
well, what argument are you happy with?
The men are like, let me know she caught an STD so I know she's cheating. Like, they're fucking crazy.
I think, if Your Honor, please, the only argument that we can honestly say is that this is a question of pure power.
Well, do you suppose the state of Connecticut could prevent marriage?
I think the state of Connecticut could prevent marriage on certain people, certain groups. Yes, if Your Honor, please. Between idiots, say, or age in marriage, I think, Your Honor, please, that...
But surely you'll agree with me they couldn't... I should think you'd agree with me that the state of Connecticut should say there'll be no marriages contracted in this state. Be no sexual intercourse of any kind, married or unmarried.
I agree with you.
Well, now, what is the police power purpose of Connecticut in telling married people, to people who are married to each other, that they cannot use contraceptives?
Well, I think, if Your Honor, please, it's to preserve...
what kind of morality? What moral purpose is
well,
that?
If Your Honor, please, it is not unheard of that the use of contraceptives themselves would be immoral. Certainly, this is a view that has been prevalent in history right up to the last few years. And
I'm not going to lie to all y'all. I now think that MAGA goes and watches this case before they come into a debate and like jay off it to it or something, because it's like the talking points are so scarily similar. It's getting weird. Oh, the
When they say "Make America Great Again," this is what they're thinking of.
Yeah, super great. 60 years ago, we were arguing if married people could prevent pregnancy. It's fucking wild.
Most groups. In Connecticut, I'm citing the brief of our opponents in one instance of the number of Catholics and Orthodox Jews in the state. If you were just to put it on a numerical basis,
well, you'd have quite a different case if the state of Connecticut compelled all married couples to use them. That's not. That's when you'd run into the argument you're now making, that this violates the religious precepts and beliefs of certain groups.
This is true, but if Your Honor please, it also would be more difficult for the state to control the result of what you might call dissolute action. That is, fornication and adultery. That's what it's there.
Well, I thought you and I had agreed that isn't involved here. We're dealing here with, by definition and on this record, with advice and the furnishing of devices to married women who ask for such advice.
Well, Your Honor, please, I think what we have here, that is true. We have here a center being used, and the witnesses that the state used in this case were, in fact, 3 married women.
Mr. Clark, inquiry, on page 15 of your brief, I don't know that I agree, but if you might provide an answer by reading what your court said in State versus Nelson. Doesn't sound like a very lofty attribution to married people, but that's the reason your court assigned. Page 15, State versus Nelson. You look at the next to the last paragraph.
Your Honor, please, that's what I was trying to get out, and I must say that I did it rather poorly.
That is the reason your state, I take it, assigns that morals are involved.
That is correct, Your Honor, please. The court held in Nelson, it, meaning the legislature, was not precluded from considering that not all married people were immune from temptations or inclinations to extramarital indulgence. And I think, if Your Honor, please.
That is the moral ground, then, upon which presumably your court has sustained this legislation under the police power.
I think it is.
That's the ground on which you're relying.
That is correct.
I want you to ask yourselves, though, in what way is that like narrow or tailored? Saying just because people can means we should legislate it just seems like a bad practice to me. I know law talks a lot about narrowly tailored like laws. I don't know if you want to go into that right now or you want to wait, but yeah.
Nah, we can keep rolling.
All right.
Anybody who has the price of a ticket to New York is immune.
No, if Your Honor, please, that is not the case, because the New York law is not that way. The New York law, as I understand it, is that contraceptives cannot be sold except for the treatment of disease. Now, certainly anyone who wants to use something as a contraceptive is not using something for the treatment of disease. And Connecticut is like many other states in this regard. We have cited some other states in our brief that hold for the same proposition, Mr. Court, please.
Many decisions of this court have mentioned. The legislation must be carefully tailored to meet the evil. If this is the evil that your state is trying to combat, you have other laws that deal with that, adultery laws, for example. Is that correct?
This is correct, if Your Honor, please, but the problem is that if contraceptives, say, are freely sold, dispensed, or otherwise used, even to married people, how can the enforcement, how can it be known that they will be used within the marital relationship? Not all people are immune from adultery. The problem would be greater.
Then you charge them with fucking adultery. Jesus Christ.
The problem of identification, the problem of conviction would be greater without it. I don't hold that I don't hold that the statute is the most wise way of putting this issue.
But as Justice Goldberg said, you do have substantive criminal statutes against adultery or extramarital fornication or non-marital fornication in Connecticut, don't you?
That is correct.
And your suggestion is suggesting as a matter of practical problems of proof, it's easier to prove that in such a relationship people use contraceptives than it is to prove that they had such a relationship?
No, I'm not saying that, if Your Honor, please. I'm saying that with the two statutes here involved, it's easier to control the problem. I'm not saying that it'd be that much easier in proving it. That is somewhat that is so, but our court has held in Tileston that the statutes as here in this case apply both to the provider and to the user. Now the other side has tried to push this right on the use all the time, but with our accessory statute we get beyond the use itself. We get into the question of the provider.
Oh yeah, just charge the doctors. That always works out good.
The disseminator of devices. And I might...
That rather begs the question, doesn't it? I suppose a person can't be convicted of aiding and abetting a criminal offense if that substantive criminal offense is unconstitutional. It's beyond the constitutional power of a state to enact.
This is a valid argument, I think, but I don't think that this statute is beyond the power of Connecticut to enact.
So you do come back to the substantive statute, don't you?
We have to come back to the substantive statute that this is a valid...
Just by the same token, I suppose you can't, under the First Amendment, free speech doesn't entitle you to aid and abet something which is a criminal offense. So I think that on either side of this argument, you come back to the substantive use statute, don't you?
That is correct. Well, there is a standing problem here, if Your Honor, please.
It's the argument for abortion laws, too.
Not in
We charge
relationship
doctors,
to the
not patients.
constitutionality of the statute, but there is a great standing problem here.
Anyone who helps the patient.
In the relationship of these defendants claiming it. As I understand, one of their main arguments was a claim of privacy. Now, it's not their privacy because they were running a center. They were running a clinic. They were holding themselves out to the world. And as a matter of and it can't, I think it truly can't be said that it is the privacy of the so-called patients involved, because in this case we had 3 women testify against them. If there was any claim of anyone had a right to privacy, it would be a right of these people.
But any ground on which the constitutionality of the basic statute could be attacked, that ground is available to these aiders and abettors.
I think that might be a fair statement, but I might point out...
Including the privacy.
Including privacy, except... no, I would have to disagree if the court please. And I would have to say, because what they are trying to do then is they would be advocating the views of or the rights, if any such right exists, of people who in fact testified for the state against them in a criminal proceeding. And I think this would be an extremely bad precedent. If defendants could claim the rights, if any such right exists, of a witness who testifies against them.
Well, this is nothing more, though, than asking whether an aider and abettor can attack the constitutionality of the statute. That's the only question.
I'm sorry.
Well, can an aider and abettor attack the constitutionality of the statute, which makes a crime out of the act he's supposed to be aiding and abetting?
I think he can, if Your Honor, please, but I think that they failed to do it in this case. I think that they could have put on testimony. They did not. The people. This case was 2 detectives and 3 women testified for the state. The defendants testified, and they had some doctors.
Are you saying that the grounds on which the statutes are attacked here weren't raised below?
That is correct. Your Honor, please.
This isn't a standing problem. Just the arguments weren't raised below.
This is correct. The arguments.
But one Weren't they passed upon by the by your Supreme Court?
Well, the Supreme Court said that the arguments of the defendants didn't merit discussion. Now, if this means they were passed upon, they were passed upon, I suppose, if you're pleased. But the only arguments that the defendants and appellants made in this case was a First Amendment argument, freedom of speech, which I understand they abandoned here yesterday. It was action, not speech, and a broad claim under the 14th Amendment. This they argued on demur, and this they argued through the case.
What? No, but the 14th Amendment covers quite a bit of territory.
Liberty and property. Liberty and property under the 14th Amendment.
Hey, Attorney Dye, you're welcome up as well.
Their rights to liberty and property in violation of the 14th Amendment was their ground on demur on the ground they argued through. As I said, if Your Honor please, it seems to me that this case is purely a case of legislative power, reduced to its narrowest sense. Does the legislature have the power to enact laws in this area? And I think the answer has to be said that it does. And then the question comes up, did Connecticut go too far? And this is it's said that this is a dead letter, this statute, but it is not. Every 2 years, the General Assembly of Hartford and...
Hey, Attorney Dye, sorry, we're in the second day of the arguments, but we're trying to finish this up. But if you have anything, just chime in and let us know.
Oh, thank you very much. I'm coming in a little bit late tonight, but this is such an interesting case. I'm excited we can hear it. Yay.
You're all good. I always love to have you. All right.
People troop up, and this is one of the most hotly debated issues before the Connecticut Assembly.
Well, do you say the constitutional issue is here to be decided in this court or not?
If Your Honor, please, I say that they have not standing to raise the issues aside from freedom of speech and aside from claims of liberty and property. And as to
liberty and property of
themselves.
Of themselves as doctors or advisors.
That is correct. Because the claim that they made, incidentally, the claim has never been made up to the time that it reached this court, that the substantive statute was void on its face. That claim was made here. Throughout the case, the defendants have always argued that as the statutes here would be applied to them, they violated certain constitutional rights.
Subsequent to Poe and Ullman, was there any further legislative action or attempted legislative action on the statute?
If I remember correctly, Poe and Ullman was in 1961. We've had a 61 session of the legislature, and bills were introduced. I think I cite the number in my brief. In 1961, bills were introduced, and they never came out of committee. They went to both houses of the General Assembly. In 1963, other bills were introduced. The bill in 63 was to repeal the statute. The House passed that, 149 to 66. The Senate committee never reported the bill out. Now, on February 10th, I believe it was, of this year, a bill was introduced. I have a copy of it here. I don't have the... it was to repeal the statute. They had a public hearing on it last week. Traditionally in Connecticut, bills do not get reported out until late in the session. So what will happen this session, I do not know. But this is something that comes up. There are bills to repeal or to give exception that come up in every session of the General Assembly. And as you will note in our brief, a good part of these arguments are based on the fact that there's no medical need I'm sorry, I withdraw that. A good part of the defendant's arguments and a good part of the brief of amicus curiae have been that there's medical necessity involved in allowing people to use contraceptives. Now, there has been testimony at the legislature by doctors prominent in the field of obstetrics and gynecology, that there is no medical necessity for the use of contraceptives. Absolutely none.
I want you to fucking imagine being a doctor specializing in lady business and being like, no, there's no medical need for that. Doesn't matter if, like, she could unalive on her next pregnancy. Although I don't know the advancement in technology at the time, so I don't know that they would be able to see. But, like, there are certain things that happen that you just can't freaking miss, you know? Or that, like, preventing sexually transmitted diseases isn't important for women or men, like, for that matter. That's crazy shit to me.
Well, the contraception itself, like the idea that I'm going to pick on the Catholics because that's the only one I understand, that you can't even talk about it. A husband and a wife in marriage are interested in knowing about birth control, and they can't even ask questions about it. I mean, that's like it's getting into some First Amendment issues for sure.
Yeah, I find it really disturbing. Like, again, this is like 60 years ago they're arguing this case. It was like giving me chills at how scarily, like I was saying earlier to Law, I was like, I think MAGA watches this to re-up on their talking points before they go into like pro-choice lives. And then maybe they skittle their diddle to it too, because it's just so scarily similar to a lot of the abortion stuff we see right now and everything like that. It's just, yeah, it irks
Well,
me.
we keep going round and round, right? We keep going around and saying, well, if you're married, you can't have this information. But what if you aren't married? And what if who you're married to isn't, the same thing that it was in the 60s? I mean, it's kind of this ongoing thing. A lot of people are asking me before too if we've ever gone through anything like this, right? With our society. We've gone through a lot of it. We've gone through a lot of this before, and some people feel that it's okay then to have some hope, and I agree. I absolutely agree. When we're talking about privacy rights, it could go on forever because they aren't specified very well in the Constitution. And so, it's like they're picking an amendment. Does this one work? No. Does this one work? No. And then meanwhile, we're just kind of getting shoved all over the place until they decide what they're going to do.
The biggest thing I can say, like, once we get crazy out of office, also, I don't do this a lot. I tend, but this is so intertwined with legality and politics. Please go vote. Like, listen, I'm not that person. I'm not going to tell you who to vote for, but please just go vote, at least on your down ballot. That's probably one of the most important things you can do. And for the love of God, we need to start demanding our legislators do their job. Now, I realize we need constitutional amendments too, and maybe that's a stretch right now, and I totally get that. But for the love of God, make sure your legislators are getting shit done. Because if they're not, they need to go. They're not doing a service to you. But yeah, sorry.
Absolutely. No, it's absolutely. And they're only here for 2 years. And so, like, that first year, you're kind of figuring out what age you're supposed to do because you don't have any seniority. And then you go in and try to do a little bit. And the next thing you know, you're waking up and boom, you got to go campaign again. But yet, that's still an incredible way to keep accountability going, right?
Yeah.
Because you only have to wait another year if there's a really bad one, unlike the Senate.
And that's the thing is, like, Congress every 2 years. Every 2 years. Like, I mean, listen, incumbents do have a lot of advantage, but it's not impossible. I'll try to stay off politics as much as possible. I apologize, you guys. I'm really adamant about just people being able to make their own choices. Look, be pro-life, be pro-choice, that's totally up to you. But I want people to be able to make their own decisions about what they want to do with their body minus government involvement.
Absolutely. Absolutely. And it gives us a seat at the table. That's what's so important here. And Ginsburg was saying that as well. Like, we don't know which way it's going to go, but I'd like to at least be asked. I'd like to have a little bit of a say here in the roundtable discussion rather than
Exactly.
just the dudes.
Because if this shit keeps going to the court, it's not going to end well. If we can get Congress to start doing their job, maybe it's going to end a little bit better. So, okay, we'll get back into this. Sorry, guys. I know you're watching. I apologize. But it's good to have you, Attorney Dye.
The necessity. It's not a medical problem. It may be a social problem, but it's not a medical problem. Just to cite some of the examples that were used in the brief of the Planned Parenthood League, amicus curiae in this case, there was a whole series of appendices about certain types of women who should not have a child, and certain heart conditions were listed. And they listed a whole group of doctors, some who say they shouldn't have children, some say that they should never have children, and some say that they should seldom have children. The whole tenor of which is that there's some women that shouldn't have any children at all. And the testimony to the legislature have been that in this particular type of heart condition, this is not so. The difference between pregnancy control and birth control, that this type of person can have a child.
Now, what you're saying would be relevant and perhaps with some persuasiveness if what Connecticut had done would be to compel everybody to use contraceptives. Then you could show that there's divided opinion about their value for certain people with certain physical conditions. But we have the other side of the coin here, and if the medical and sociological and religious views on this subject are divided, and it adds up on net balance to be relatively neutral, then what we have here is the freedom of people, of married couples, to do this if they want to. And therefore, I don't quite see the relevance of what you're telling us now when you remember what this case is about.
Well, if Your Honor, please, I can only say that married couples do not have freedom to do what they want. This has been a Connecticut decision, and this is the Connecticut holding.
Well, I still come back to what the basic purpose under your police power of your state.
I'm sorry. That was a crazy statement. Like, married couples don't have the right to do whatever they want. This is up to the state of... I don't know. Maybe it's just because I grew up in this nice in-between time where people weren't entirely in your business and we were on a good track. And then I watch this and then I think about where we're at right now and I'm just like, it's like 5 steps forward and like 20 steps back. It's amazing.
Yeah, it certainly is.
Now, could Connecticut decree that married people live separately in dormitories for men and for women except for 2 weeks out of the year under the due process?
No, I wouldn't say so, if Your Honor, please, but parenthetically, we might say that under the welfare powers that this is practically what's happening in a great number of cases. In order to collect welfare, people must do this, and unfortunately, this has been what has happened under the welfare legislation.
Where have we heard that before, right? Where have we heard it?
Told you, they watch
There
it
is
to like
a
cram their
bill
talking
that
points right before
the
they
session
get
has to
live.
end in June. It's either the first or the last. I don't know.
Either house taken any action on this?
They have had committee hearings, a joint committee hearing last week. The bill is number 2462, House Bill 2462. It's a simple bill. It says Section 1, Section 5332 of the General Statutes is repealed. This act shall take effect from its passage, which is Section 2. To my knowledge, there has not been a report out by the House committee. I have spoken to some people in the legislature, and it is the opinion that I've gotten from them that there may be some legislation this year, but it probably will not be that legislation. There might be some legislation which might more probably be some of the other states, certain restrictions on sales. But there has been no report out. And this is all conjecture on my part.
You're suggesting additional legislation leaving this statute on the books, is that it?
Amending this statute, I might, probably repealing the statute as written and substituting, therefore. Now, it was argued before that some other amendments other than the 1st and 14th were brought into the case. We heard yesterday the 3rd, the 9th, the 4th, possibly the 5th Amendment. And I can only say to the court that these were not brought up in the record. It does not support.
Repeal the 3rd.
Well, I heard this.
I think it's when
I made a note.
Sorry, hold on. It's just TikTok Studio is weird on my computer, so I kind of have to move stuff around. I think at least from what I heard them saying earlier, they were bringing that up to reinforce this 9th Amendment, right to privacy. That's why they were bringing it up.
Yeah, and that's in the opinion too. They cite 1st, 3rd, 4th, 9th, and 14th. I think
what's with the 3rd? What's with the 3rd? Can I ask? That's courting soldiers,
well, you can't
right?
put soldiers in your house because you have a right to privacy.
Yeah, reinforces a privacy interest.
Oh, right. Thank you very much.
That was my assumption. Sorry, I probably shouldn't answer. I should have let Law answer.
No, that's exactly right.
My bad.
That was one of the biggest concerns they had in the Declaration of Independence with Thomas Jefferson. So great point. Sorry.
No worries. All right.
I'm just not sure, in all honesty. Oops, sorry.
No, you're good. Go ahead.
I'm not sure, in all honesty. It really bothers me when they start hanging their hats on the 9th Amendment because it is so vague. That's where you're going to be building your doctrines up. And it's a little bit uncertain. And it bothers me that there's such a loophole that, people can be like, well, this is private. And again, that's how we lost Roe as well. So that's very frustrating to me. But now I feel better because I've purged and I haven't paid for therapy, but I've been able to say what I need to say.
We're doing therapy this TikTok. Sorry, go ahead, Will.
Well, no, it's it's a fair point because I think Thomas even noted that Griswold needed to be looked at after Dobbs or in Dobbs. So the opinion in Griswold, spoiler alert for everybody who's hasn't read it in the past 60 years, is that there is a right to privacy that emanates from the what they call a penumbra of the amendments, and so it's not an explicit right, but through the 9th Amendment, even those rights that aren't explicitly granted doesn't mean that you don't have them. And so they said that, through the penumbra of the 1st, 4th, 3rd, 14th, that there is this right to privacy. And that was the basis for the decision. But as we saw with Dobbs, the right to privacy is subject to the whims of the court.
Well, right. And I think, too, my other piece I would add in here is the relationship that we've got. Married couple. It's like we don't have 2 singles or 3 singles. No, don't be getting 4 singles together, everybody. I'm just gonna put that out there. It's too much. That's too hard of a relationship. I mean, I respect you, but don't do it. Anyway, I think because it's married couples, they were able to take this argument a little further. Because of that. And then also that's part of the holding too. If you're a married person and you want to get information, you should be able to get it. But again, had it been a single person, I don't think it would have turned out the same way.
Law was kind of talking about that earlier, just the kind of slow build that they were working towards. Because on Wednesday, we're going to do Eisenstadt v. Baird, which if it applies to married people, why doesn't it apply to single people? So, yeah.
Oh, I love that case. I love that case so much. Oh, I'm excited now.
Yeah, I'll do Wednesday, and then Friday we're gonna do Roe v. Wade. So it's gonna be a busy week. But yeah, it's just this argument. It's just like it keeps repeating, and I hate it so much. I just icky feelings.
Your Honor, please. That's when I'm saying that they should not be in this case. That they were not in the record. That's yes. It might have relevance had it been raised at the proper time, because the Connecticut procedure, which I understand the court has to follow, if I can recall a note number 9, I believe it was, the majority opinion of the MAP case, was that in criminal procedures, this court would adopt the procedures of the state in which it came up. And Connecticut has very strict procedures on how to raise issues. I point them out in my brief. Now, the only issues that were raised, in fact, you have to allege, the court does have this power, yes it does, especially on constitutional questions it does. But generally speaking, the court restricts you to the rulings that you have made or cited.
Law made a good point that I didn't think about, because just evolution of technology and shit. There might have been somebody with a mic, because this is 1965, running back and forth between the justices. And I was like, I never thought about that, but that's very likely possible. It's just wild, how far we've come.
Yes, I agree.
They're asking basic questions about birth control and condoms and stuff. And I'm just like, man, I love the internet. It's freaking amazing and horrible at the same time. It's, alpha and omega, I guess.
And as we pointed out, there's one thing that was brought up by the defendants in their argument. It wasn't cited in their jurisdictional ground, and that is the fact that they claim they were cut off at the trial level from getting into the availability of contraceptives in the state of Connecticut. And I quote now from the transcript of the case, because I want to be exact on this, on page 47 and 48. This was a question of Detective Berg, a member of the Haven Police Department, who was called as a state's witness, cross-examination by Ms. Rohrbach, page 47. Now, in the course of your investigation, Detective Berg, did you ascertain whether these products, and she's referring to contraceptives, were available anywhere else in the city of New Haven? Answer, I did not. Then there was an objection taken. Now, the court below ruled on the question of whether the objection were properly taken, but the interesting fact of the case is that the answer got out before the objection did, and the answer was I did not. There's no place else in the record that the availability or lack thereof of contraceptives came into the case at all. And they were not precluded from bringing this up if they wanted to show. Not that we would say that it would make any difference, assuming, for the sake of argument, that you could purchase any type of contraceptive any place. It would be no different, it seems to me, than being able to buy a number, which you can buy, I must admit, almost any place. It's rather difficult to enforce the gambling laws. Any statute that might be said to be not too popular is not easily enforced. In short, I think we get
some numbers racket, but you have had many prosecutions over the lifetime of this particular act, haven't you?
Many prosecutions,
yes, but you can hardly cite any at all in this violation of this law.
That is correct, Mr. Chief Justice. And yesterday afternoon, at the conclusion of the court, the other gentlemen that I had sponsored for membership in the bar were all prosecutors, or assistant prosecutors, of circuit courts in Connecticut. And we put our heads together. And it seems that every one of us has handled cases along this line. Now, none of us here,
If you got a pity and you're one of the 19 people
none of
in
us
here,
has
will
had
you
those
just send
cases
the little heart me thing?
go
Because
out.
it helps
They've
boost the
always
live.
been
Thank you so much.
disposed of for one reason or another. I know I handled one, and the one I handled involved two charges. The first was statutory rape.
Was what?
Statutory rape. The second was...
A little different.
That is correct. And therefore, the second charge was using a contraceptive. In this case, it was a condom on the part of the man. We threw this out. So that in the books and the records, you don't get this at all. Now, in the other cases, one of the gentlemen told me that he had a case of some high school children.
What?
They had high school children, and he just quietly changed the charge. He didn't. He thought this might be a crime that might come back and haunt them, and he didn't want this on their record, so he just disposed of the case, changed the charge, so he wouldn't even have to nolly it.
I couldn't quite hear you.
I say he changed the charge, Your Honor, so he wouldn't have to nolly it, because if he had nollied it, the charge as was would be on the record. He substituted a charge, therefore, breached the peace. So it would be less. Now, if Your Honor pleases, it seems that the other side has pointed out that Massachusetts, that Connecticut had adopted certain views from Massachusetts cases, specifically the Gardner case, and that Massachusetts had in fact later changed its view. And that is, quoting the Corbett case in Massachusetts and the Walensky case the same year, that in order to prove a violation of the sales statutes, that they had to affirmatively prove that these devices were not being used for the purpose of the prevention of disease, so-called. But what they forgot to inform the court was that 4 years later, there was another Massachusetts case, and it's the case of Commonwealth versus Goldberg, that severely changed it back again by convicting a druggist who had condoms on display, just on display. And they
How dare he?
The court in Massachusetts held that the specific intent did not have to be proved in that particular case. Now, this one,
Like, can't get rid of the Puritans.
so that was a Massachusetts Supreme Court case.
Yes,
That's,
yes, I see.
that
That's one of them was referred to in
I refer,
your Supreme Court.
no, if Your Honor, please. Our Supreme Court had referred to the Gardner case, and our opponents had pointed out that since the Gardner case in Massachusetts, the two other cases had come up restricting it. And I'm just pointing out that since the cases that they referred to came up, a third case had come up in Massachusetts, which brings it back nearer to the original Gardner case. I should like to point out that there has been a problem that prosecutions in Connecticut have been under in this area, and it could be seen best by the case of State versus certain contraceptive articles, which is probably one of the more miscited cases in Connecticut history. At the time this case came up, and you'll recall that this was the companion of the Nelson case, this was a raid on the supply center of the Waterbury clinic, health center or clinic. This was a police raid on the basis of a warrant. Now, at the time that this came up, the statute that empowered the warrant was the gambling statute. Connecticut had, at that time, no general search warrant statute. There were statutes for narcotics, for gambling, for firearms. The gambling statute read something to the effect of for gaming, gambling, or other crimes. Now, this case, this warrant, was an attempt to get in under the or other crimes. And the Connecticut court held, and I believe rightly so, that the other crimes listed in that gambling statute were other crimes of the same ilk, gambling, etc. And therefore, that there was no grounds under that statute for issuing a search warrant. Now, that case has been cited many times, and our opponents cite it, for the fact that Connecticut does not say, cannot condemn or claim as nuisance contraceptives. And I don't think the fair import of that case can be used for that to cite it in that manner. Your Honor, please, it seems that what the court here is being asked to do is, as I started to say yesterday, was overrule Gardner and overrule the cases of Margaret Sanger. Both cases in which this court has held that it was within the state power of the states to control these contraceptive clinics. They were also asking the court, in a way, to overrule the case, the Tileston case, allowing doctor here to claim rights, so-called, of the patients, although, as Mr. Emerson admitted yesterday, that the rights of the doctor in this case are essentially the rights of Ms. Rohrbach, that the clinic or center here could have worked without a doctor. I think the best example of what the court should do, at least according to our way of looking at it, was the words of Mr. Justice Black in the Ferguson case in 1963, because actually what we're concerned with here, to quote, we are not concerned with the wisdom, need, or appropriateness of the legislation.
He's invoking Plessy v. Ferguson.
That's what I was saying. That's crazy shit.
Shit, I missed it. I was about to go look up the Gardner case because, like, I was like, well, I want to see what they're talking about. How did I miss that shit? Really, Plessy?
Yeah, I think if you pull it back just a few seconds, then you'll be able to hear.
Let me see if I can. Give me 1 second.
But he referenced Black, and Black was the dissent in Plessy, right?
Oh, I can't remember. There were a couple of them.
It says, I think the best example of what the court should do, at least according to our way of looking at it, was the words of Mr. Justice Black in the Ferguson case in 1963, because actually what we're concerned with here, and we quote, we are not concerned with wisdom, need, or appropriateness of the legislation.
Perfect. That sounds right.
Wait, what year did he say Plessy?
63.
That can't be right. It must be because I bet they're auto-generated and they just kind of hold on.
I think the best example of what the court should do, at least according to our way of looking at it, was the words of Mr. Justice Black in the Ferguson case in 1963, because actually what we're concerned with here, that we're quote,
well,
we're not concerned with the wisdom, need, or appropriateness of the legislation.
Yeah, that date doesn't sound right at all.
Oh yeah, because Plessy v. Ferguson was
had to do with
1896,
Well, I think
somewhere around there.
I think in
economic
this
policy, there was no impingement on the kind of personal privacy and freedom involved in this case.
I think this case, if Your Honor please, is the way it comes to this court, is economic. This is the people running a business. And if you look especially at Mrs. Stevens, the Stevens woman who testified for the state, a girl married less than a year, a graduate student, her husband a student. She was charged $15 by this center for a tube of jelly. Now, we've heard arguments about poverty, and I'm not that long myself from college to know that $15 is an awful lot of money. And this seems to me to be, these people are running a business. It's that simple.
Well, you and I agreed earlier, I think, to come back to the substantive use statute, however you start in this case, don't you?
That's right.
And it's to that statute that
That
I was
is the stumbling point.
To that statute that I was averting and indicating by my question whether or not there might not be a difference between a state's economic regulation of commercial businesses in that state and this kind of a statute, which affects whether or not it does so with constitutional validity was the question before us, but which certainly affects the individual privacy and freedom of human beings, and not in their commercial activities, but in those private activities of their lives.
There's no question about that, if Your Honor please, but I think the issue can be avoided on the grounds that these individuals can achieve the same result by different means, by not using contraception.
Or by not getting married. So.
Possibly. But I think also that it's too bad, in a way, that this case came up now, and I say that because
Are they like trying to like play a game here because they want more babies born, but they're advocating for abstinence among married couples who don't maybe want to conceive? Like, I don't know. This is such a he said so much fucked up shit in this argument. I don't even know where to begin.
Yeah, get in your time machine and go backwards.
Keep in mind, BJs were considered sodomy at this point in history, so they just didn't know what they were missing.
I'm just
True
saying.
story.
What I wouldn't have given to be a fly on the wall during this.
Oh, I don't know. They probably would have like gone like helter skelter on everybody because things are so crazy there.
Yeah, I'm like halfway convinced that at least a quarter in this courtroom right now are drunk, including the guy who's talking.
Oh, I think more than that.
Well, I'm trying to be generous here. I'm trying to be generous.
All right.
Year or so, there appears to have been fantastic work done in this field. Now, I cite in our brief an article in the, I don't recall the page in the brief, but I cite an article in the Lindacre Quarterly, the February 1965 issue, where a Boston gynecologist has come up with a method of being able to pinpoint ovulation to one day in a cycle. Now, if this works out, if this is so, then contraceptives, that is, devices that are being used
There's your
to
fertility
prevent
tracker
pregnancy
MAGA
will be
Q.
passé. There'll be no need. There'll just be no need.
That's stupid.
Excuse me, Your Honor?
If you're just coming in here, I'm telling you that MAGA, they watch
Well,
this before they
those
go
methods,
debate.
if Your Honor, please,
I'm
would
not
be
even
impossible, absolutely impossible, because those methods would involve a rhythm system, which the state has held does not violate this statute. I suppose I don't think so. I would not claim that.
On the basis of your argument, I don't see why not.
Well, if Your Honor, please, what we're saying is that the state can argue that people cannot go outside their own homes and get things and use them in their homes. Now, this is not to say that people can just...
No, but the reason you give us, which supports the power of the state to do this, it seems to me would equally apply to an amendment to the statute which barred the use of the rhythm method and made it a crime to use it. Why wouldn't it?
I suppose it might, but it's not an issue here before the court.
Then shut up about it, dumbass. Jeepers.
Mr. Chief Justice, may it please the court, with respect to the ending question and the right of the appellants in this case to assert the constitutional rights that are involved in the use statute, I call attention of the court to the Shuttlesworth case, which last term, which raised that same issue. So far as appellants raising the broad issues in this case, we point out in our brief in the footnote on page 16 those sections of the record in which all the issues that are now urged before this court were consistently raised in the courts below. With respect to the question of possible legislation in Connecticut, I call the attention of the court to the fact that that would not solve the issue of the two defendants who have been convicted in this particular case. With respect to the question of enforcement, regardless of the issues of whether or not there have been... I'm sorry?
You say it wouldn't solve the problem of these two. Don't you have an abatement statute?
I'm not sure about that, Your Honor, quite how that would operate. I'm sorry?
What about Bell and Maryland rights?
Yes, I realize your reference, but I'm not sure how it would apply in the Connecticut situation or what this court might do with it if it got back here. No, you're right, Your Honor.
Not just because it's in time.
On the question of enforcement, apart from the issue of whether or not there are sporadic cases brought, the issue before the court is, and the fact is, that the statutes are being enforced against clinics. Dr. Buxton has been convicted for his participation in a clinic. And that is the key issue with respect to the enforcement of the statute here. Now, what this means is not only that contraceptive devices are not available as such to persons who cannot afford to go to private doctors, but that the whole range of medical services which is supplied by a clinic
Hold on.
are
They
not
are public
available
doctors?
to those people. The medical services which are necessary in health cases, and particularly the newly developed devices in the contraceptive field, require medical supervision. All of those services are not available to many citizens of Connecticut who cannot afford private practitioners.
Mr. Emerson.
You repeatedly say that it doesn't apply to private physicians. Now, where in your record do you find that? But I understand counsel to say that it does apply to them just as well as anybody else.
Your Honor, by apply I meant it isn't enforced as to them.
Well, how much has it been enforced here?
It's so weird hearing questions
It's
during the
enforced
closing.
against the operation of a clinic. It has not. There have been no cases in which a physician has been prosecuted apart from the clinic cases. It has not been enforced as to them. I'm not saying it has no impact upon them, because it applies to them, and they would be violating the law. And in that sense, it applies to them, but it has never been enforced as to them. Also, I was thinking of situations where the patient could go outside the state for medical advice. But the important point about the enforcement, Your Honor, is that it is enforced as to the centers. So, and not only as to Planned Parenthood centers, but as to hospitals and any other public facilities, so that all the people who rely on facilities of that sort are denied medical supervision in this important field. And
can we assume, as a question, as a matter of law, that this is applied only to clinics and is not applied to doctors?
The reason I say it's not applied to doctors...
Does the record support that? Or is that argument?
The reason I say that, Your Honor, is because that is what I understand Poe against Ullman decided, that it was not applied to doctors. And the record does not throw any more light on that. I'm relying on the decision in Poe against Ullman.
Well, are we dealing on the record of Poe versus Ullman here, and not this one?
No, but there's no indication that the situation has changed. I just didn't want to fight Poe against Ullman over again.
Well, we didn't vouch for the record, for the truthfulness of the record. We were dealing with the record we had, which was inadequate in Poe, and I'm just wondering if we haven't got the same thing here.
There's nothing further in this record on it, Mr. Chief Justice, but I would say that essentially the matter is not the most significant aspects of the case. It's a secondary matter, because the important thing here is that it is being enforced against Dr. Buxton and Mrs. Griswold. And it is being enforced in a way which denies medical services to a great many people. And I perhaps didn't answer sufficiently the question yesterday as to what the people of Connecticut were suffering as a result of this statute. The fact is that a great many people in Connecticut are denied medical supervision in an area of great importance to them, and it is a matter of great importance to a great number of people in Connecticut.
Mr. Emerson, don't want to interrupt your argument, but before you sit down, I'd like to know what you do, if anything.
I just need to ask this real quick. In the context of this case, if they went to another state, could Connecticut still penalize that patient?
Not likely, just because of jurisdictional issues.
Gotcha. Okay.
And actually, at this time too, and everybody just fact check me always. I'm just always saying that. But Connecticut was just the example they were using because there were other states trying to do the same thing as Connecticut when it came to their statutes too. So I'm not sure what they would do about people coming in and out. I'm not sure if we've got the privileges and immunities piece locked in, but yeah, I would say huge jurisdictional issues.
Yeah, no, it's just to me, like, again, I keep repeating this and I know I keep saying it, but I'm sorry. Like, this is so eerily similar to shit we see right now. But it's that whole, like, go to another state and it's like, no, you should be able to get service in the state you're in. Like, you should not have to, like, and I know Connecticut's small and I get that, but they also have Massachusetts, which is a little bigger, like, in several other states. So, like, you should be able to get the service like medical services you need within your own state. Like, I don't know why that's so crazy.
Well, and I had a question too, real quick, because they're saying, well, all medical facilities except for this clinic, but and they were saying they're all public. But I thought there were private hospitals. Did I think incorrectly? Like, we have a lot of religious hospitals, and those are like made by the religious people. And so for me, I'm like, I don't think that's a public hospital. I mean, it can be utilized that way, but technically I'm not sure that that's what its category would be. You know what I mean? Like, if someone was having a miscarriage, you would go into a Catholic hospital here and they're like, you gotta go. We don't do that. Like, that was kind of already in place for the private, well, I'm calling them private, for these kinds of hospitals and medical facilities.
I'm going to guess because a lot of the conversation has revolved around Planned Parenthood clinics specifically, at least from what they brought up. Now, I don't know if this was a Planned Parenthood, like, I can't tell you that, but I know, like, when they were talking about clinics, that's kind of what they talked about. So back in the 60s, this is kind of insurance evolving into the game. It's not that they didn't have it, it's just wasn't as prevalent. Like in the 40s and 50s, you could have a $50 baby. Basically, you go in, you have like a 2-day stay, you deliver your baby, blah blah blah. So it's a weird time, and I don't know, like, what they had when they're talking about a public capacity versus a private capacity. So I'm curious about that too. I may have to dig into that one. I'm majored in public health, and I don't even know what to tell you there because it's kind of weird framing for me. So yeah.
Well, I think it's just something to kind of chew on, for a little while. Just an idea, like, wait a minute, what's going on? And again, it's because I'm in such a rural area, honestly, that, we can't have public hospitals because the government won't pay for them. Like, we have like one government paid for clinic in our capital city, and then everything else is just all, Lutheran, Catholic, whatever. So,
I mean,
just putting it out there, food for thought.
Maybe at that time, I know that they said that the federal government had appropriated funds for some clinics in DC towards the beginning of the argument, but I'm gonna have to look into it because now I'm intrigued. Thank you so much, Attorney Di, because now I got questions that I need answered. Okay,
go, and you don't even have to write those questions down because you're just a spring chicken still.
No, I usually do, actually. It's really bad. I have almost everything down. But I'm going to look it up right now while we're listening to it because now I want to know.
About the precedents in this court. First, Margaret Sanger against the people of the state of New York in 251 U.S. And second, Gardner against Massachusetts in 305 U.S.
People against Sanger is not a precedent in this case, Your Honor. That involved a prosecution of Margaret Sanger in New York under the New York statute, which prohibited the dispensing of contraceptives except by physicians. She was not a physician, and that was the issue of the case, that since she was not a physician, she was covered by the statute. And there's no such question in this case, because we would not say that a state law which provided for the dissemination of contraceptives through a method of prescription by physicians would violate constitutional rights. So that was not involved.
That was an equal protection case, was it? I noticed it was argued to the court.
No, it was a prosecution under the New York statute.
What was her claim in that case?
Her claim was the statute was unconstitutional.
Because it denied her equal protection, or why? Because it allowed physicians to do it, not laymen?
No, it was not based on that ground.
What was her claim? Do you remember? I don't know.
I'm sorry, Your Honor. I don't. I think it was a due process First Amendment.
The hell?
Claim.
You go in there without knowing what you're talking about.
What your thought was about the...
I think that's not significant.
How about the Gardner case?
The Gardner case is much closer, and all I can say on that is that the court simply dismissed the appeal. The Gardner case involved the validity of the Massachusetts statute, which was a sale statute, and interpreted the statute to be without exception, as the Connecticut statute's been interpreted. Similar questions were raised, so that so far as the sale aspects of it is concerned, it's a very similar case. It did not involve the use aspect and all the privacy questions that are involved in the use aspect.
I understood you to say yesterday, Mr. Emerson, that you made no distinction between the doctor in this case and the director.
I made no distinction apart from the question of the requirements that a person have a license to practice medicine, so on. Those aspects of the case, which of course are different. I would say that dissemination, that in this case.
Okay, I got an answer. In 1964, Connecticut, the landscape of public versus private providers was defined by a highly fragmented pre-Medicare Medicaid system. This was argued in 65. I'm assuming the case probably took place in 64, 63. 65 is when the civil rights, or not civil rights, sorry, what am I thinking? The Medicare Medicaid Act was signed. But healthcare, education, and civil rights dominated by privately run institutions, with public government sectors serving primarily as the financial safety net and basic infrastructure regulator.
There is no difference, because the statute prohibits dissemination by any person. And therefore, whether it was a physician or whether it was an assistant to a physician, in that case they're both in the same have the same rights in that respect.
There's been some statements, the arguments about the difference between business institution and somebody who's not a business institution. There's a statement of fact about how this clinic operates, correct, as made in the court's opinion?
Yes, sir.
It is a business institution, isn't it?
No, it is not a business institution.
What do they get paid for?
Well, there was a sliding scale of fees ranging from nothing to $15.
Who gets the fees? The public?
No, the plan. It's run by a non-profit organization, Planned Parenthood.
What does the doctor get?
The doctor serves without fee.
Is that right?
There it is.
Yes, I'm quite certain about that, Your Honor. There is no element of profit in this whatsoever.
What does Miss Griswold do?
She was executive director of the Planned Parenthood League of Connecticut.
What does she get out of this clinic?
I think nothing, Your Honor. I think there was no
compensation. Statement correct, however, given by the court's opinion?
I didn't recollect that the court said she got a salary from Planned Parenthood League of Connecticut, which sponsored the Senate, but she got no salary from the Senate.
I'm not asking that with the idea that I think that phrase makes the Constitution a difference.
Yes.
Because some suggestion has been made that you might.
Mr. Evans, can I ask you another question? Apparently, the state would concede that you certainly that the defendants can raise the constitutional issues about this statute, which the married couple could raise, provided they were litigated in court below and things like that. But how about the health argument? Here were two healthy people, apparently, these two married women who testified. Can we really be legitimately concerned with the way this statute might apply to two other married women who might have health reasons for wanting a birth control device?
Yes, I think clearly so, Your Honor, because in the first place, it would really make no sense for this court to rule on the narrow issue of the three women that happen to be called as witnesses in this case. And then, if it decided as to them one way, the clinic would then operate, and the next day 3 more women would come in and raise different questions. It seems to me that there is no sound judicial administration in taking it on that narrow view, when actually it raises, for all practical purposes, all the types of problems that would come up in case any woman came in.
But these people are being prosecuted for giving advice and furnishing devices to these particular women who testified, aren't they?
Yes, Your Honor, but I think
not in a lot of other situations.
No, but they are subrogated to the rights of those women. And those
Only
women,
those women, yes.
Yes, Your Honor, but those women may be healthy today, but not tomorrow.
Right.
One thing.
What if let's assume the woman was prosecuted for using, and she says this statute is unconstitutional because it would prevent a sick woman from using it. And are you sick? No, I'm not sick at all. I just want to practice birth control.
Well, I think it's clearly within the doctrine of the Aptheker case, for instance, Your Honor, in which a passport was denied to one member of the Communist Party, and the question the court considered whether how that statute would apply to other members of the Communist Party.
Telling you, man, they watch this and stuff just rolls together for them. The commies and the birth control are coming for you.
So that all aspects of the case would be considered. I think the court would be drawing the line much too finely if it attempted to separate the different types of patients that might come into that sentence.
How about your First Amendment argument in the... is that really seriously involved here since there was furnishing of the device?
Yes, Your Honor. The fact that I have not discussed the privacy argument or the First Amendment argument, I hope will not be construed that I do not emphasize them. I do. The First Amendment argument is significant in two respects, both in the fact that the statute is void on its face because it permits counseling. It's assisting, abetting, and counseling the use of contraceptive devices. That term could mean that a mother who counseled her newly married daughter to use contraceptives because of her ill health could come under the statute. It could apply to a doctor who had a patient in his office and discussed the effectiveness of a contraceptive device with her. He would be running a serious risk.
Doesn't that assume the underlying invalidity of the statute because a mother could not counsel her daughter to commit adultery?
Well, I'm not so sure about that, Your Honor. Mr. Justice Stewart said in Kingsley Pictures case that freedom of speech did include the right to advocatability. And
not to counsel an individual person to commit it. There may be a difference.
Not a specific crime.
I would think that advocacy would be more likely to be outside the First Amendment than counseling, which is a personal, face-to-face relationship and would probably be of less public social significance than advocacy. But we would argue two things, Your Honor. One,
this is an aiding and abetting statute in connection with a specific crime. This is not a statute which says it shall be illegal to aid, to counsel about birth control. This is an aiding and abetting statute about aiding and abetting the commission of a specific crime.
That's true, Your Honor, but the question of whether a person had violated the aiding and abetting statute by counseling various people on the use of contraceptives would raise many borderline cases so that a person would not know what his rights were, and also we would contend that it would violate the First Amendment substantively because we would contend that a doctor did have a right to advise people to use contraceptives. And
on this basis, there'd be an awful lot of aiding and abetting statutes that would be declared unconstitutional.
I think that's right, Your Honor, in the sense that the aiding and abetting statutes grew up quite independently of the First Amendment and have never really been reconciled. The fact that there have not been more cases indicates that it's not been too pressing a situation, but I think sooner or later there will have to be a reconciliation.
Yes, to take your argument seriously, you have to assume that the aiding and abetting statutes really would be applied to people who simply counsel generally rather than in connection with a specific crime. Either that, or you would say, we have to think that you're urging that advising to commit a specific crime is protected by the First Amendment. You're not doing the latter, are you?
Not perhaps as to all crimes or in all circumstances, but there is a point at which advising in a sense of advocating is certainly protected under any doctrine.
I want to just stop right there for a second. We've only got a few more minutes left in this, and then we'll discuss this briefly, and we may talk more about it on Wednesday because I don't want to keep law and attorney die if they're exhausted. I'm hanging in there, but
my nails are wet. That's all.
I just want to point out that, like, what they're talking about, the sense of advocating is certainly protected under any doctrine in this court. We currently have states criminalizing doctors who even deign to recommend that a patient may pursue an AB. But this is also so this is where it gets weird because then, they gave what was that lady's name? There was a case earlier this year. She was a counselor and she was like, I should just be able to talk to my patients and do what they ask me to do and blah, blah, blah. If they want to pursue like religious and conversion therapy, I should be able to do that too. Just saying. Weird.
Jermison, I think that's quite a different thing. You can advocate as a matter of advocacy, repeal of any law, and say you're against the underlying principle. But it's pretty far-fetched to say that assuming the validity of a law, First Amendment protects counseling the violation of such a law.
Mr. Justice Brandeis, you recall, said there are some types of advocacy which even under the clear and present danger test would be permitted under the First Amendment. It depends on in his view, on the extent of the evil. Hence it would depend on how serious the court thought the consequences were under that view.
Of course, here as a matter of the record, the activity involved is not counseling, it's conduct.
Quick.
Correct. We're dealing here with conduct. The doctor...
What's up, Di?
I do want to mention, I cannot remember which case it was, but the clear and present danger test, which came out of a particular case that had a really weird name. I can't remember. Anyway, that has been basically cut down to almost nothing. So the rule that they're talking about here was a big, huge deal during this period of time, but we do have case law decades down the road that says, nope, this isn't completely correct. So just wanted to put you there. Clear and present dangers only give you 50% of what you need.
Gotcha.
Shank.
Oh,
Shank?
Yeah, which was largely overturned by Brandenburg.
Oh, thank you so much. Perfect. There you go. See? Laws. Look at Law over there knowing all this stuff.
He's ready. He's
Yeah.
like, get these arguments over. I got stuff to say. We're here for it.
What else to do with that? Well,
Tribe,
There was
and the center, and the Mrs. Griswold to help supply them. So we're really not dealing with counsel.
We're not directly, Your Honor, and it's quite true, as I said yesterday, that those aspects of it are outside. Our position is that the statute is void on its face because it infringes the First Amendment by permitting the possibility of a punishment for counseling, and thus inhibiting free speech, and also that those aspects of free speech which were protected by the First Amendment in this case were lumped together in the findings of the court. The action and the speech were all put together in one grab bag, and the court came out with its conviction, and we consider that also a violation of free speech.
Reference to all these things in talking about privacy and so forth, invalidate all laws that punish people for bringing about abortion.
No, I think it would not cover the abortion laws or the sterilization laws, Your Honor. That conduct does not occur in the privacy of the home. In the privacy.
Some privacy is a rule, and the individual doesn't usually want it made known.
Well, that
Very
aspect,
private thing.
that aspect of it is true, Your Honor. But those are offenses which do not involve the type of enforcement apparatus as to what goes on in the home.
A lot of it goes on in the home, undoubtedly.
Part of it does, Your Honor, but the conduct that is being prohibited is in the abortion cases takes place outside of the home normally. There is no violation of the sanctity of the home.
Apart from that, I take it abortion involves killing a life and being, doesn't it?
Yes,
Rather,
of course.
is that a different problem from contraception?
Oh, yes, of course.
Isn't it different in the sense of the state's power to deal with it?
Oh, yes, of course. The substantive offense is quite different.
All abortions involve killing, murder.
Well, I don't know whether you need to characterize it that way, but it involves taking what has begun to be a life.
The state thinks each one of them is wrong. Passes a law, try to forbid it being done. Relate to pretty closely analogous situation. These brought about usually in the same way.
Yes, Your Honor, but that case is different from this situation because in the abortion cases, Connecticut does not apply this moral principle. It is the use of an instrument to prevent births taking place. But they do not apply the moral principle that it can never be done. In Connecticut, abortion is allowed where it is necessary to save the life of the mother or the child, so that the basic moral principle that Connecticut is trying to enforce here, they simply pay no attention to in their abortion laws. It's a completely inconsistent application of the principle. They don't take it seriously in abortion cases, only in contraceptive cases.
Mr. Emerson, I understood Mr. Clark to say that the question of the unconstitutionality of this act on his face was never raised below, and that this is the first time he heard of it. Is that correct?
No, Your Honor. In in the demurs to the indictment, we have all this in our brief on page 16. The demurs to the indictment, it was alleged that the statutes were unconstitutional as applied to the defendants, and it's on that basis that they make that assertion. It was put in that language in order to avoid the problem of the Charleston case. But the appellants have consistently asserted that the statutes were void as a whole for all the reasons that we have given here, and we point out the places in the record where that issue was consistently raised below and was consistently passed on by the courts below. All the issues that we have raised here were
you point out there that as applied now, did you specifically attack the Constitution on its face as being unconstitutional?
No, it just said as applied to them. At that point, in the demurs to the information, but at other points, the broad arguments were raised that we have raised here.
Is that in the record where we can find it?
Yes.
Where?
The citations are given on...
You have the citations in your brief?
Yes.
All right. Very well.
Sorry, y'all. I'm trying to get this to cooperate with me right now, but it does not want to, so we'll just delete it. Cool. Okay. Any hot takes so far? That was so, like my state, it was scary. I put it in the comments for myself. So our SB 8 here, which is our abortion bill, the language is so vague that the aiding and abetting, it doesn't outright ban it, but it basically says if you're even talking to your patient about this being an option, you could have a real issue. Thoughts?
I think that that's fair. I think that's fair to believe that. And also the support staff, anyone that's around when you're going through this, even just with your doctor, they're scared. I mean, they're scared to even talk about it. I've heard stories where the doctor just is like, here's a sheet of paper and write down blah, blah, blah. Trying to be all, MI6 about it. And I think that's terrible too, because of course you need support in those moments. And you take your families and friends away, and even your doctors, your midwives, away from you, and you can't talk to them. I think that's very devastating to the pregnant mother.
Well, and see, so the sad part is like, SB 8, and then I want to get back into this, is that like, I know because I've talked to my friends that work in the medical community, it's not necessarily that they're afraid of the patient doing anything. I mean, that's always a risk, but they're more afraid of the people around them saying something, which is where it becomes super problematic because you got a nurse in the room. Let's say you're a male doctor, you're dealing with a female patient, obvious reasons. You have a female, you just don't know sometimes. So I just thought it was interesting to kind of like loop that back in. I'm sorry to get off like on that, but we're talking about this and there's just some really uncanny similarities in some of the language and some of what they talked about in this case. So, I mean, granted, it's different. It's birth control versus abortion, but it's still irky, I guess. Law, you got anything?
No, I think you hit it there. It's the parallels are a little shocking.
Gotcha. I don't have a lot to say on this. We can kind of like maybe just look at the decision real quick. Like, law already told y'all the decision. But let's hold on. Give me 1 second.
Well, we do have a lot of new people. They may appreciate a
Yeah.
quick summary.
Gotcha. So this, sorry, everything's everywhere right now. Sorry, guys. So in 1879, Connecticut passed a law that banned the use of any drug, medical device, or instrument from furthering contraception. A gynecologist at Yale School of Medicine, Seeley Buxton, opened a birth control clinic in New Haven in conjunction with Estelle Griswold, who was the head of Planned Parenthood in Connecticut. They were arrested and convicted of violating the law. Their convictions were affirmed by higher state courts. Their plan was to use the clinic to challenge the constitutionality of the statute under the 14th Amendment before the Supreme Court. The question was, does the Constitution protect the right of marital privacy against state restrictions on a couple's ability to be counseled in the use of contraceptives? And the conclusion is a right to privacy can be inferred from several amendments in the Bill of Rights, and this right prevents states from making the use of contraception by married couples illegal. 7-2 decision authored by Justice Douglas, the court ruled that the Constitution did in fact protect the right of marital privacy against state restrictions on contraception. While the court explained that the Constitution does not explicitly protect a general right to privacy, the various guarantees within the Bill of Rights create penumbras or zones that establish a right to privacy. Together, the First, Third, Fourth, and Ninth Amendments create the right to privacy in marital relations. The Connecticut statute conflicted with the exercise of this right and was therefore held null and void. Goldberg, Warren, Brennan concurred, Harlan concurred, White concurred, Justice Black, of course, joined by Justice Stewart, dissented. Unpersuaded by the loose reasoning of the majority, Black felt that there was no way to infer the Constitution contained a right to privacy. He also dismissed the views of concurrences that it could be found in the 9th and 14th Amendment. And Justice Stewart, joined by Justice Black, filed a separate dissenting opinion, and Stewart argued that despite his personal view that the law was uncommonly silly, he felt the court had no choice but to find it constitutional. Yeah. So,
Sorry, my nails are wet. Sorry about
no,
that. Okay,
you're
I got
good. Sorry, y'all. I know. It's super late and it's 1:07, but I'll tell y'all what. I'll be live on Wednesday for Eisenstadt v. Baird. That whole case, less than an hour long. Because we're gonna do Roe v. Wade on Friday. Maybe if y'all want to come back Wednesday, of course you're not obligated to. I know y'all are busy people. Maybe we could kind of discuss a little bit more about it. I just know it's late and everybody's exhausted. So, and Law's working on his 20 trials. He's got to get ready. So,
hey, only 12.
Oh, you're only 12 left? All right.
I didn't count them up, but that sounds about right.
What's the problem? Give yourself an hour, boom, you're in court. You're good to go.
Law's
You're quick on your feet, Law. It's okay.
Listen, he's got to get his shower on. He's got to get his bonnet on. He's got to do the eye cream and the beard oil and get in bed.
Oh, I appreciate the skincare.
I know, right? Like, you got to appreciate a man who takes care of his skin. It's freaking peak.
For sure.
But yeah, maybe we can do that on Wednesday so we can all have like more coherent thoughts about it. I don't think there's much to add other than we're really rolling back privacy for me right now. I want to read a little. I'm actually going to go watch your YouTube video where you dissect Griswold so we can really go through this decision. So I can feel like I've read the decision, but I like it when you do it because you're like, look at this, look at this, look at this. And it's just shit I don't catch. So I love it.
Well, fabulous. There's some good creators on here too that have done little bits of it as well if you're interested.
Yeah, I follow Brino and I follow a few others, but there's probably some I'm missing if you want to send them to me. I try to follow everybody I can, so but yeah, thank you two for being here and sitting through it with me. I appreciate it. But this is a key case for privacy. And we're going to be going on to Eisenstadt v. Baird. Sorry, I think I said Blatt the last time. It's been a long day. Eisenstadt v. Blatt, which is the one that said, hey, if married women can have access to contraception, why can't single women too? Then Friday we'll do Roe.
That's right. So it's bedtime now, though, right?
It's bedtime.
Like
I'm sleepy.
my left eye's trying to go to sleep right now, so I'm like, yes, stop it.
Fair enough. All right. Any final thoughts?
Nothing here. Thanks for doing this again.
Yes.
Appreciate y'all.
Great
I appreciate y'all
host.
for coming by. Thank you so much. Oh, yeah, that's right. I'm sorry. If you're still in here, I'll be live for SCOTUS opinions in the morning, probably about 8:45, 8:55. I don't go on 30 minutes before because I wish I had that kind of time in my life. I'll be on about 8:45, 8:55, but that's Central Standard Time. So if you're on Eastern, it's an hour forward. And then if you're on the other, you can do the backwards stuff. So yes, 8:45, 8:55 Central Standard Time. But I'll be on for decisions.
Okay.
Again, thank everyone for coming. I appreciate y'all so much.
Land the plane, honey. Land the plane.
I'm trying. Anyway, all right. I love you all. Everybody have a good night. We'll be back on Wednesday. Love you. Bye.
Take care.
Bye.
Bye.